Good, yeah.
Test, test, test.
Morning, everybody. It's time to resume the inquiry this morning. Just a few things to mention. First of all, in terms of documents, I see the core documents library again is being updated. I think there are a couple of things still to go on, though. I'm sure they'll be added. The AOMB plans and the Joint Objectives Group PowerPoint that Mrs. Simpson talked to. Conditions. We mentioned that briefly before the end of yesterday's session, and I think there was discussion between that from the main parties. I think Mr. Hardy mentioned that there was the possibility of a document for us to look at this morning.
Yes, and indeed, I spent my evening just having a look at the conditions, which are already in a really good place, but there were additional conditions to add. So yes, there is a document, 5 copies. Thank you very much, Ms. Howard, for printing that off. I thought they'd be distributed. They haven't. Just given one to Ms. Dozier. You won't have had a chance to look at it. So presumably we're not going to get there until this afternoon anyway. So shall I distribute those? I'm conscious of the fact the council haven't seen these, the party haven't seen these. So should we not give you a copy until at least we've had some initial feedback? Is that?
I'm entirely happy with that, Mr. Hardy, yes.
There's nothing radical in here, but it may be best to have a discussion between the parties before you see it at all.
So you're going to provide a copy to the planning authority,
to the council, and then a copy to Jog, yeah. Can I just say that it looks different, just informed to the draft conditions that were presented.
Yes.
Different typeface, the numbering is different, but all the conditions that were agreed, so the technical conditions are all there. They've not been changed.
Yes.
It might be in a different place with a different number, but then there are the additional conditions. So things like the fire management plan, the construction traffic management plan, the SEMP, and so on. So I don't want people to think, oh goodness, this is completely afresh. Yes, it is a fresh document, but it is based very much on what had been agreed. But I'm not being prescriptive. Absolutely, it's open for discussion. I'm not saying this is the end final word, but I hope it's just moved things on, hopefully.
Good.
Caroline, I've got another set there.
Thank you, Mr. Hardy. Next, I just wanted to mention briefly the point that I raised yesterday about the land at the eastern end of the north parcel, which was included, I think, within the proposals put forward by Mr. Mason, but it's outside the red edge. And I think we left it yesterday that the applicants would look into what was intended there. It may be early days for that, but I just don't want it being forgotten about.
Yes, absolutely. I confess, with working on the conditions, I didn't take instructions on that, but we will do that today.
Thank you. And then another one, I think it just applies to your team, Mr. Hardy. And that's professional qualifications. As you know, it'd be usual for the report to include a list of appearances at the end. And in terms of your team, some of the professional qualifications which would normally be added are descriptive with in their introductory sections. I think what I find helpful is if you could provide me with a list of how the individual witnesses, excuse me, would like their qualifications to appear.
To be described, yeah, absolutely.
Rather than me just guess.
Yeah, we'll do that, yeah.
As far as the other main parties are concerned, I have those. Storage of boxes over the weekend, Ms. Daly. Will that be possible? I certainly don't want to be lugging my box on the train this evening. Can you check
Yes,
and come
I
back?
think you'll have seen Mr. Greaves nodding. That's
Yeah,
fine.
okay.
That's fine to store
Good.
boxes here over the weekend.
Thank you. And then in terms of the procedure for this morning, we've got Dr. Tilford on flood risk. My intention will be to deal with things in the same way as with highways yesterday, just initially to give Mr. Harding an opportunity to identify the areas of concern. I appreciate you may not want to do this, Mr. Hardy, but there will be the opportunity if you wish to put any questions to him before we move on to Dr. Tilford.
Pretty sure I'll do the same as I did with highways, if that's all right. But thank you for the opportunity.
Yes. And finally, could somebody from the council organise some water this morning? I don't think we've got that just yet. Those are my points before we start. Mr. Hardy, anything you want to raise? Stay with Mr. Harding.
No, sir, water was going to be mine as well, actually. So that's good. Thank you.
Okay, thanks. Right then. Mr. Harding, in terms of jog and flood risk, that's covered in your statement of case at the paragraph at 3.3. Do you want to mention anything about that, or are you?
Yeah. Well, I think sort of as we did with transport, it
Yes.
may be useful if I just summarize the key points and
Yes.
bring out the things that we will have concerns about.
Yes.
So should I do that now?
Yes, please.
So I think the first point I made in that was that Little Wymley particularly does have a long history of flooding, and it goes back many years. And I think it may well be worth just referencing the Wymley Neighbourhood Plan, which is CD 40, pages 34 and 35, and to just see the images there, which I think sets the scene for the concerns we're going to have and the sort of answers we're going to be seeking, if you're able to do that. CD 40, and the images are actually in total on pages 32, 33 and 34 and 35. And I mean, the earliest of those images goes right back to 1968. Yeah, so the first one on page 32 is in the High Street, where you can see the brook is completely overflowing. The next one is at the bottom of Priory Lane. Again, very old, but if we whip on to page 34, you'll see we come up to more modern times in 2014, and the top picture there is Stevenage Road, and the picture at the bottom is further along Arch Road, Stevenage Road junction by the mini roundabout. So you can see this is not a problem restricted to just the Priory Lane. And then the final one on page 35 is quite significant, as the area by the Plume of Feathers and the High Street at the bottom of Priory Lane. Now, the purpose of mentioning those, and I mean, there's been some quite severe flood damage in properties, and that is that I think something like 83 people along the high street and can't actually get flood insurance. The reason to mention this is that we start from a level of significant anxiety, as you will see from those pictures, that each year over that there is some impact of flooding. And not all the water ends up in the high street, as you've seen. It can be Priory Lane, it can be along to Arch Road. And certainly in the autumn and winter, the water table can be very high. You'll see next Thursday the community orchard, and when planting there in 2020, literally as you dug the hole was filling up with water before the trees could be put in. And there used to be a football pitch at the top there, and that also was constantly waterlogged. So we start from a premise of having a flooding problem, and we start from the point of view that we have certainly a high water table at times. And it's the Milksea Cottages name. They used to be called Black Tar Cottages. Not a great image, but they were very damp, and they were tarred to stop the dampness. So that's the background. Now the scheme now includes the water management structures on both parts of the site, and that is positive. And they were added, and I'm sure the expert will talk to Westwood's report on CD31. And they've been added in response to the Herts County Council LFA stated concerns. And this was very much when flooding was an issue originally raised right back in the time of the first Walmley Parish Council Zoom meeting, when Mr. Roden was asked and felt that the water runoff from the panels, etc., would simply drip on the ground, soak away, and be pretty much no change. I think we're pleased that since then the LLFA have insisted on the scheme that's been put in place, and we understand that there is now a marginal betterment. Now, given the problems we've got, marginal betterment is a step in the right direction, but naturally our concern is that any change can have a risk of the negative. And I think we have two concerns that have arisen really during the course of the last few days. The first one relates to the 32,000 metal posts that would be piled into the ground to a depth of 1.5 meters. Now, we've got a whole lot of land drains, clay pipe land drains and mold subsoil runs running through, which are obviously a pretty important part of the drainage systems. And we do have concerns that 32,000 posts are going to significantly damage, just by the law of averages, they're going to damage those land drains. In addition to that, we have gained even more concern, I think, over the trial trenches that Ms. Roy described to us on Wednesday. Now they're going to, if we recall, they were going to be 50 meters by 1.8 meters by 1.2 meters. Then I think she felt hand digging down to 1.5. So we've got two things are going to happen with those. First of all, they are sure to go through a significant number of land drains as well, because there's so many of them, disturbing the historic land draining. And secondly, the soils, as we discussed, are going to be dug out, and they, of course, are not going to go back in the same way and provide the same natural drainage. So the combination of these two elements, we fear, could undo the small level of betterment which is claimed and promised by the surface water management scheme. And that's a major concern. We'd like to address that, and we do feel that we've probably got to have some more betterment to deal with the latest concerns of what will happen to the land. And I think that sums it up from us. Thank you.
Thank you, Mr. Harding. Mr. Hardy, having heard what Mr. Harding has to say, do you still wish to proceed in the same way?
Yes, I'm going to proceed in the same way. Yes, call Miss Dr. Tilford to deal with that.
Okay. Ms. Daly, do you wish to ask Mr. Harding anything?
No, thank you.
Okay. Right. Mr. Hardy, then, please, if you'll call your witness.
Good morning, sir. Good morning, everyone.
So you have a summary proof, you have a main proof. Your summary is at CD 162 and your main proof is at CD 163. By way of introduction, you are Managing Director of Wheatwood Services. They're a consultancy firm specialising in flood risk and drainage. You've held that position since 2015. Qualifications-wise, BSc Hons in Environmental Science from the University of Lancaster, MSc Engine Water Resources Technology from the University of Birmingham, and a PhD from the University of Salford, and an MBA from the Cranfield School of Management, Chartered Water and Environmental Manager, Fellow of the Chartered Institution of Water and Environmental Management, and a Chartered Environmentalist. Currently serving as an elected member of the CIWEM Professional Standards Committee, which is responsible for overseeing the maintenance of professional standards and ethics within the water and environmental management profession. You worked in the field of hydrology, water engineering and flood risk management since 1988, initially as an academic and thereafter as a consultant, initially with large multidisciplinary consultants before joining Wheatwood in 2010. Is all of that true and correct?
That's correct.
You set out some more about the background and your compliance with professional standards in your proof, which you can take as read. So I'd like you to look at your summary. The way we're going to do this, for the benefit of members of the public, it's relatively short, is to read your summary. And then once we got to the end of that, there'll be some supplementary matters, Dr. Tilford. So you don't need to read out the first parts of the summary. We've dealt with those, but you could start at paragraph 1.5 of your summary, please.
Yes, thank you. I'll have to sort of calibrate the volume of my voice. So hopefully, if you can't hear me, wave at me and I'll speak up. If I'm deafening you, perhaps wave at me as well and tell me to quieten down a bit. So I've been the technical lead for Wheatwood on this project from inception. I've personally reviewed flood risk at and in the vicinity of the site. I've undertaken a walkover survey of the site and visited the local area, including Little Wymondley. I've also overseen site-specific hydraulic modelling and the development of a scheme to manage surface water runoff from the developed site. Before I go on, sir, if I may, I just wanted to just make one, it's a point of accuracy in my proof of evidence, if I may. I think it was in paragraph 1.8. I said I wrote the submitted FRA report. Strictly speaking, that is not correct. The report was prepared by one of my colleagues, although I had input into it and reviewed it. So I just wanted to make that correction as a point of note, if I may. Yes, paragraph 1.8 in my proof of evidence, which says I prepared the site-specific flood risk assessment. In fact, strictly speaking, that report was prepared by a colleague.
Thank you very much for that. And if you go back to your summary, leads us into paragraph 1.6. So the evidence is presented in your proof of evidence. That's your work, is it?
Absolutely. Everything else is entirely
Good.
mine.
1.6 onwards then. Thank you.
The evidence and opinions presented in my proof of evidence are true and professional judgments based on the scientific evidence and professional experience. The planning application was accompanied by a flood risk assessment report and a technical note. The flood risk assessment was informed by planning policy, relevant technical guidance, and also a considerable experience of solar farm developments. As I confirm in my proof of evidence, the Environment Agency does not object to the proposals on flood risk grounds. The lead local flood authority, Hertfordshire County Council, however, has maintained its recommendation of objection, even though the matters it raised in its consultation letter dated 14th of February 2022 are addressed in the aforementioned technical note CD 31. Notwithstanding this, the lead local flood authority previously accepted that if the local planning authority approved the application, the requirement for further detail could be secured through the imposition of planning conditions. The basis of the lead local flood authority objection relates not to flood risk to the proposed solar farm itself, which is at a
Might
low...
just be a bit too close to the mic.
Oh.
It's just popping in and out.
Apologies.
Judge,
Is that better?
Yes.
Apologies. I did warn you. The basis of the lead local flood authority objection relates not to flood risk to the proposed solar farm itself, which is at a low risk of flooding from all sources, but that development of the site for use as a solar farm would increase off-site flood risk. This is a concern shared by a number of local residents, as articulated in some of the letters of objection to the proposed development. As I set out in my proof of evidence, there is a long history of flooding in Little Wymondley, including along Priory Lane to the west of the development, most recently in 2014 and 2016, but also since then, December 2019 and January 2020. A detailed investigation commissioned by the lead local flood authority following the 2014 flood event confirmed the source of flooding to be Ashbrook, a watercourse that drains land to the north and northeast of Little Wymondley. The report identified a number of causes, including insufficiently sized culverts, blocked debris screens, inadequate maintenance along and of Ashbrook, and a tributary watercourse, often referred to as Priory Lane Stream. Priory Lane Stream discharges into Ashbrook in Little Wymondley. The site drains to Priory Lane Stream. Concerns that the proposals would increase the risk of flooding along Priory Lane and Little Wymondley due to an increase in surface water runoff from the developed site is therefore understandable. To address the concerns of the lead local flood authority and of local residents, a detailed scheme for managing surface water runoff from the proposed solar farm has been developed. The scheme is effectively in two parts: an element to manage surface water runoff from the access tracks and areas of hard standing, and an element to manage overland flow generated from the panelled part of the site. The scheme is presented in detail in the technical note, CD 31, and is summarised in my proof of evidence. In brief, though, the scheme includes the provision of 3 flood storage basins and 3 surface water drainage basins, SUDS basins. These storage facilities would temporarily store runoff from the developed site and release it at a controlled and restricted rate. I'm unaware of any empirical evidence of the effect of solar farms on surface water runoff and hence flood risk. However, the definitive research work on the matter was published in an American research paper in 2013, CD 89. And may I just say that's not some esoteric academic paper that I've sort of identified. It's a well-referenced document. I know Essex Council, for example, specifically refer to that document in their guidance on solar farm development. So it's a well-known piece of research. The paper recognises that rainfall would run down the face of the panels and drip off the lower edge onto the ground below, and thereafter infiltrate into the ground and or flow over land, as would be the case if the panels were not present. The research presented in the paper demonstrates that the effect of solar panels on surface water runoff is negligible if the panelled site comprises well-managed grassland, which would prevent the formation of a distinct drip line. But that peak runoff rates and volumes may increase significantly if the panelled site comprises of bare earth. My proof of evidence presents findings based on detailed site-specific hydraulic modelling. The findings demonstrate that the implementation of the proposed mitigation measures would provide a reduction in peak runoff from the developed site for the 1 in 30 and 1 in 100 storm events, both present day and including an allowance for climate change for the lifetime of the development, as long as the site comprises managed grassland. In reality, the reduction in peak runoff resulting from the development is likely to be greater than that presented in my proof of evidence, because the site is currently farmed and comprises bare earth for a significant part of the year. Whilst the analysis demonstrates that the proposed development will reduce peak runoff from the site and therefore reduce off-site flood risk, the reduction will not solve the pre-existing flooding issue along Priory Lane and in Little Wymondley. This is principally because the site constitutes only 5% of the total catchment of Ashbrook draining to Little Wymondley. Nevertheless, the aforementioned analysis does demonstrate that the proposals comply fully with national planning policy, including the National Planning Policy Framework, Paras 159, 167 and 169, local planning policy, including policies SP11, NE7 and NE8, of the North Hertfordshire District Council local plan, and policies FR1 and FR2 of the Wymondley Parish Neighbourhood Plan, as well as the Lead Local Flood Authority's 2021 guidance for the developers on the management of surface water drainage, and DEFRA's 2015 non-statutory technical standards for sustainable drainage system. North Hertfordshire District Council's position in respect of flood risk is summarised in its statement of case, in which it states, and I quote verbatim, the effect upon flood risk was also carefully considered, with amendments to the proposal made to address the comments of the Lead Local Flood Authority. The Council considers that these amendments, along with conditions suggested by the LLFA, would ensure that the impacts of the development upon flood risk would be adequately mitigated, and a limited benefit would arise from the proposal based upon the attenuation ponds and water detention areas, potentially reducing overland flow of storm water from the site. The proposed drainage strategy is intended to improve drainage compared to the existing greenfield situation through reducing the flow of water from the site during and following storm events. This would make a contribution towards reducing flood risk or its effects in Little Wymondley, where there is a history of flooding. Whilst the overall effect is likely to be modest, it would nevertheless be an improvement to the existing situation, and this is a planning benefit to which limited weight should be attributed. So in conclusion, I believe that the proposed solar farm would be safe from flood risk for its lifetime. B, implementations of the measures presented in the submitted evidence would reduce peak runoff rates from the developed site, and accordingly, that the proposed solar farm would, 1, not increase off-site flood risk, and 2, would contribute to a reduction in off-site flood risk. And finally, C, the proposals comply fully with national and local planning policy and relevant technical guidance. In my opinion, there's no reason why the application should not be approved as a result of flood risk or drainage matters.
Thank you very much for reading that. Now, it's quite high level. I'm not going to descend to the minutiae of the flood risk assessment, but there are 4 matters that are sort of somewhere in the middle. So matter 1, just with a little bit more detail, I'm going to ask you to explain whether you think the site is at risk of flooding or not, and if it is, the measures that are being taken to mitigate that risk.
Okay, so the submitted flood risk assessment report, the FRA report, assessed the risk of flooding to the site from all known potential sources as required by national planning policy. The assessment concluded that the main part of the site is not at risk of flooding from the sea, from rivers. It's not at risk of flooding from reservoirs or from canals, and is at negligible risk of flooding from groundwater. Overall, the assessment concluded it was at a very low risk of surface water flooding as well. The assessment indicated the presence of about 4 overland flow pathways across the site, 2 across the northern part of the site, that's land to the north of Gravelly Lane, and also 2 to the south of, on the southern part of the site.
To just stop you there, members of the public, what's a flow pathway?
So the site is sloping when it rains, as local residents will be very aware. The rainfall generates runoff, which effectively flows across the site, and that can be concentrated into particular overland flow pathways across the site. You can get an element of sheet flow, and you can get some preferential drainage pathways developing when it's in the event of very heavy rain.
That's helpful. The reason I ask you is because you deal with this language day in, day out. For our members of the public, we just need to take it a little bit slowly in terms
Understood.
of some of the technical terms. So flow pathways, okay, we've got that.
Yeah.
And the flow pathways, could that include water originating from outside the site?
Generally not, because the site is sort of forms pretty much the northern and eastern boundary of the catchment. So the site is fairly.
Did there were any higher land adjacent?
There's a little bit of high land just beyond the northern boundary of the site. However, there is a drainage ditch which runs along the northern boundary of the site, which effectively intercepts that rainfall and conveys it through the drain, so that doesn't enter onto the site.
So the flow pathway should only be picking up water from the site itself.
Correct.
Yeah, thanks.
Okay, so that's what a flow pathway is. You do some hydraulic modelling. What did that show?
So the request of the Lead Local Flood Authority, we undertook some detailed hydraulic modelling, and effectively that confirmed the presence. I say confirmed because the Environment Agency has published maps showing surface water flow pathways, overland flow pathways, but the Lead Local Flood Authority asked us to do our own detailed analysis of that, and effectively our analysis confirmed the presence of those pathways, and they're evident and developing. The 1 in 30 event. The 1 in 30 event is an event, just to explain my technical language, an event that would be expected to occur on average once every 30 years. So in itself, an extreme storm event. And that the maximum depth of flooding during pathways generated during that event was less than 100 millimeters, even during the 1 in 100 event, including an allowance for climate change. That sort of evidence is presented in, I think, in figure 2 of the submitted technical note CD 31.
So just, I mean, explain what 1 in 30 is. Presumably 1 in 100 is the same, but just 1 in 100 plus climate change. What is that?
Yeah, so as I said, the 1 in 30 event is effectively the storm event that would be expected to occur on average once every 30 years on average. That doesn't mean that you can't have a 1 in 30 event occurring today and then another 1 in 30 event occurring in a month's time. It would be unlikely, but it's not impossible. The 1 in 100 event is the same thing, but it's a more extreme event, which you would expect to occur on average only once every 100 years. But again, it's a statistical construct.
Okay, so that's the modelling, and it tells you what you might expect to find. Do you go out and ground truth that? Do you go and have a look?
Yes, I personally undertook a sort of a walkover survey to see whether I could identify any distinct overland flow pathways across the site. And I have to say, although the modelling sort of identified 4 potential flow pathways when I was on site, I mean, it's a large site, obviously. It was very difficult to discern any sort of particular flow pathways, with the exception of one located in the northwest corner, cutting across the northwest corner of the northern part of the site, which sort of correlated to a sort of a low valley across that corner of the site. All I'll say there, though, in reality, runoff is conveyed under the site in that area because there's a pipe which connects the drain that I mentioned a moment ago, sir, to effectively the start of Priory Lane Stream. So there's I think it's a 300 millimeter pipe, which was presumably installed many years ago by the farmer, I'm guessing, just so that he didn't have to cross a ditch to get across the field. So there are no well-defined overland flow pathways, even though the modelling sort of tends to pick them up.
Okay, in terms of components then, so the panels, the inverter transformer, containers, the storage building and so on, are they on the ground or are they raised?
Well, actually they're all raised. So the inverter, the panels, obviously the inverter transformer containers, storage building, control building.
So as a result of that, if they're raised, does that mean that or what happens to the overland flow pathways in terms of obstruction?
Well, the benefit there is they don't obstruct any overland flow. So overland flow will just pass underneath the containers and the buildings.
There was being concern raised about cable installation, and there's a 700-meter length along the road located in land indicated to be at higher risk of flooding from Ashbrook. I want to understand what implications there were from that.
Yes, as I said earlier, I mean, when I referred to the site being at low risk of flooding, that's not true of part of the cable pathway. The assessment, the flood risk assessment, confirmed that part of the grid connection route, I think it's about a 700-meter length along Stevenage Road, is actually indicated to be located inland at a high risk of flooding from Ashbrook. That's flood zone 3 in national planning policy sort of parlance. And that's shown on the Environment Agency flood map for planning, which is figure 5 of the submitted FRA.
So the question really is, those cable installation works, in your view, do they or do they not increase the risk of flood elsewhere?
No, I mean, that was a concern that was initially expressed by the Environment Agency, but we subsequently confirmed that the cable installation would not increase flood risk elsewhere because the cables will be laid in a narrow trench located within the highway. And my understanding is that relatively short lengths of trench will be excavated, the cable installed, and then the trench sort of backfilled, so that the trenches won't be left open sort of overnight, and there'd be no storage of any arisings, any materials taken from the trench within the floodplain. So I think it's safe to conclude that no, the installation works would not increase flood risk anywhere or cause flood risk.
Okay, we'll come back to trial trenching for archaeological purposes at the end. But just leaving that aside for the moment, your conclusions then, and indeed the degree of confidence that you've got in whether or not the proposals can accommodate overland flow.
Yes, I'd state with confidence that the proposals would accommodate, not disrupt or interfere with the effectively the existing flow regime, the existing overland flow across the main part of the site. And then, as I've just mentioned, that the cable installation process would not increase the risk of flooding, and that the proposals would be safe from flood risk.
Okay, that's the first topic. Second topic then matters the concerns that have been raised about a pre-existing flood issue in the locality. You've heard Mr. Harding this morning. There's a lot of concern, high degree of concern. That's I think he described that as the starting point. So I want you to just explain or give your evidence on that, please.
Yes, I'm very aware that concerns have rightly and understandably been raised regarding local flooding, both by the lead local flood authority and of course by local residents. As I mentioned earlier in my summary proof, the principal source of flooding in Little Wymondley is Ashbrook. Ashbrook drains an area so of approximately 14 square kilometres. Approximately 2 square kilometres of this catchment comprises land to the northeast of Little Wymondley, including the site. And that subcatchment is drained by an unnamed watercourse, although it's often referred to as Priory Lane Stream. To provide context, the site itself constitutes approximately 5% of the Ashbrook catchment draining to Little Wymondley. Now, although I didn't provide a map illustrating that in my proof of evidence, the extent of the site in relation to the Ashbrook catchment can be identified, for example, from figure 2.1 of CD 88, which is which is the flood alleviation feasibility study prepared by McCloy Consulting.
That's folder 7. Figure 2.1, I think it is, of CD 88.
The page number, Dr. Tilford. What was the figure number, please?
So it's figure 2.1.
All right, I've got 1, 2.
And it's an appendix A.
So sorry, sir, it's on page 5, but as Mr. Hardy correctly states, it's also in an appendix, I think appendix 1, but
Right.
have you found that, sir? It's,
I'm nearly there. It just takes a while on the system.
it looks like that, if I can wave that at you.
Huh. Page 5 on the document I've got. CD88, you said, didn't you?
Yes, CD88.
Yeah, page 5 is a glossary.
Oh,
Page 10, is it? Oh.
There's a difference between the hard copy and the electronic
Ah.
copy. I think that's so page 10 of the PDF.
it's in section 2. And it's on the second page of section 2 of that report.
Right, 'cause page 10 is something else again.
I apologise, yes, the page numbers must be different.
Right, section 2, I've got that.
So it's a figure with a lot of green,
Yeah.
a map.
Looks like that to me.
That's the one, sir, yes.
I don't know what's happening with the version I've got. Very strangely, in section 2, the first figure I've got is figure 321. It doesn't.
Shall I give you a hard copy?
I think, yeah, to save time, please, Mr. Hardy.
That's the right one. That one.
So, yes, sir, just to explain that figure, I mean, that shows the entire catchment of Ashbrook down to just beyond Little Wymondley, actually. So that's the area shaded in light green and also in dark green. But the area in dark green is actually the catchment drained by what I've referred to as the Priory Lane stream. So the total catchment area of the light green and the dark green area is about 14 square kilometres. The Priory Lane catchment is about 2 square kilometres. And then the site itself is about 0.88 square kilometres. And sort of falls within that dark green area. So my point there, which I made earlier, was that actually the site itself forms about 5 or 6% of the entire Ashbrook catchment. I'm not underplaying the importance of the site in terms of runoff generation, but I'm just providing some context there.
Okay, so that's down to the catchment history of flooding. The purpose of the question really was to get into those concerns of that heightened level of anxiety. So a little bit about the previous flood events.
Yes, well, as Mr. Harding mentioned in his comments earlier, Little Wymondley has a history of flooding with reports of flooding incidents dating back, I've seen, to 1926, several flood events between 1926 and 1956, in 1968, 1993, in 2000, 2001, December 2013, February 2014, March 2016, and most recently in December 2019 and January 2020. Following the February 2014 flood event, Hertfordshire County Council as lead local flood authority undertook an investigation into the flooding as required by Section 19 of the Flood and Water Management Act, the so-called Section 19 report. The findings of the investigation were presented in
Slow down a bit, please.
I apologise.
Going to the 2014.
Yes. So as a result of that flood event, the lead local flood authority undertook an investigation into the causes of that flood event, as required to do so by Section 19 of the Flood and Water Management Act. And the findings of that investigation were presented in the Section 19 report, which is a core document, CD 87. And the Section 19 reports, and I'm picking bits out of this, I guess, the Section 19 report states that both Stevenage Road and Priory Lane were closed by Hertfordshire Constabulary during that event, and that there was confirmed internal flooding of 5 properties. I think I'm correct in saying 4 residential dwellings and maybe 1 commercial property. It may have been the pub.
Given my copy of the core document volume to the inspector, so I now don't have that. I might get one, but if there are page references, could you guide the inspector to those, please, Dr.
Yes.
Tilford, because I don't have the document in front of me anymore.
Okay, so in terms of the road closures, that's page 15 of CD 87. I'm somewhat nervous now because I'm hoping my page numbers correlate with everyone else's page numbers.
As if by magic, I've now got a second copy, so we're all right.
Please-
So
please-
do you want
Please
to?
correct me? Shall I continue? Because the Section 19 report also states on page 10 that the catchment responds quickly to heavy and prolonged rainfall because the catchment comprises of clay, which permits minimal infiltration. And the flooding event of 7th of February 2014 was caused by a combination of heavy rainfall on the 6th and the 7th of February, but also a series of storms in the preceding 2 months. And it says that on page 15. Perhaps just to explain that a little bit more, effectively it meant that the catchment was saturated due to a couple of months of heavy rainfall prior to the rainfall that then occurred on the 6th and the 7th of February. So the antecedent conditions were that the catchment area was saturated, then some exceptionally heavy rainfall came along on the 6th and 7th of Feb, which meant that virtually everything was translated into overland flow and a rapid response. So the Section 19 report identifies a number of factors that contributed to the flooding. I'm going to throw a lot of page numbers at you here again, sir, with apologies, but that includes blocked trash screens on page 29, blocked culverts, pages 20 through 25, also page 28, undersized culverts, page 28, blocked road gullies, page 90, overgrown and or heavily silted channels, open channels, page 29, runoff from fields and agricultural field drains, which I'll pick up later actually, because I know Mr. Harding mentioned about field drains. That's on page 28. Soil compaction due to farm machinery, page 28. ploughing of fields, page 28, vehicle bow waves, page 29, and an unmaintained water meadow, Corries Mill, page 30.
So they're all
So-
lots of page references, but
Yeah.
they're all gathered together in the table. So that's table 3.5.1, which is the possible causes of flooding. So those references you've given,
Yeah,
they're in that.
correct.
They're in that.
They are.
They're all in that table. They're described as a possible cause of flooding, and then the second part or the second column is a possible explanation. You see the textual descriptions there. Is that right?
That's correct. Yeah.
Okay. So that's all possible causes. What was the outcome of that section 19 report? Were there any recommendations made?
Yes, it made a number of recommendations on pages 37 through 41 for the various risk management authorities, for riparian landowners, and also for Wymondley Parish Council. However, the report concluded on page 41, and I quote, "There would not appear to be any simple course of action that would reduce the probability and impact of flooding to Little Wymondley. The potential for a flood alleviation scheme is limited due to the confined nature of the watercourses and cost-benefit viability."
And just to finish that sentence, the paragraph is or goes on to say that the parish council may wish to consider developing a flood plan for the village with involvement and assistance from the local community to prepare those at risks for what to do before, during, and after a flood event. That's the final paragraph, isn't it?
Yes, it is. It is. And just to go on, I mean, in 2015, Hertfordshire County Council commissioned a consultant to investigate the feasibility of options to alleviate flooding in Little Wymondley. And the consultant reported its findings in August 2015 in the document that I referred to previously, CD 88.
That's the McCloy
That's the
consulting.
McCloy Consulting
Yes.
report, yes.
Uh-huh.
And that's a detailed technical report, but the findings of the report were generally consistent with the section 19 report. In respect of Priory Lane specifically, the report states that the drainage network is inadequate and undersized, resulting in floodwater being routed along Priory Lane. But, and I quote, "It is infeasible to provide a flood alleviation / arterial drainage type scheme that would prevent flooding of the village up to the typical design rainfall event, the 1 in 100 plus climate change event."
So and I think that if you want a reference for that, that is paragraph 6.2. That's the conclusion section, and that's internal page 42.
Yeah.
So bringing those points together, got reports, you've got recommendations, you've got that sort of conclusion. What's your overall view in relation to the history of flooding and that level of concern that Mr. Harding articulated?
Well, it's a genuine and proper concern. I mean, flooding is miserable when it affects people and property, and it is hugely disruptive and has many impacts on mortgageability, insurability of properties, and so on. So it's a real issue, and I'm afraid it won't get easier because of the effects of climate change in the future. So a part of the thrust of the second report was to identify, and there's no singular cause. There's a whole number of different contributory factors, which makes it very difficult, as well as a number of different responsible authorities. So a number of the recommendations relate to property level flood resilience, to try and make individual properties more resilient and resistant to flooding. But I think the overall arching finding was there's no single sort of silver bullet here to prevent, if you like, the future flooding in Little Wymondley. So it's, if I can paraphrase the findings, it's a case of adaptation rather than prevention. That was a sort of my take on that.
Sure what the computerized voice was, but anyway, matter 3. So that's the background and history. So the question then becomes, well, look, are these proposals going to increase flooding along Priory Lane and Little Wymondley? Now, I think we've got to a point, Mr. Harding was in his evidence prepared to accept, look, there is betterment, but I just want to explore with you the evidence to back that up. So are the proposals going to increase flooding?
No, they would not increase flood risk off-site. I think the contrary is true. The proposal would contribute, as I've said earlier, to a reduction in off-site flood risk. I mentioned the academic paper CD89 that published peer-reviewed research has shown that solar farms have a negligible effect on the hydrologic response, i.e. runoff rates and volumes, if, and this is important, if the pre-panelled and panelled site, or the panelled site, comprises of grassland. It does also state that runoff rates and volumes could increase potentially significantly if a panelled site comprises bare earth. Now, in this instance, the sort of the opposite is true. The site currently comprises bare earth, at least for part of the year, due to the nature of its current use, whilst the panel site will comprise of grassland. So this in itself would be expected, in the absence of any other mitigation measures, that would be expected to reduce peak runoff rates from the site.
Okay, so that's helpful. You've got bare earth and you're putting grassland on it. So why then have they built into the scheme? Why are there surface-based attenuation storage areas? So
we've developed what I can only describe as sort of a belt and braces approach. And I have to say, I've worked on many solar farms, and the measures that are proposed to mitigate the generation of runoff or from the site exceed anything that I've personally done on other solar farm sites. So we have 3 surface based attenuation storage areas. They're proposed to store runoff from the panelled part of the site, and 3 surface water attenuation basins. Again, to attenuate runoff but this time from the access tracks and from the compounds. So there are effectively 6 storage areas within the site, 3 on the northern part of the site and 3 on the southern part of the site, all of which will be retaining surface water runoff, overland flow, and then releasing it, storing it temporarily and then releasing it at a restricted rate. I can explain in more detail if you wish, regarding the internal site access tracks and the areas of hard standing. So rainfall infiltrating into the access tracks and the hard standing areas will be conveyed to Priory Lane stream or to existing drainage ditches, and the surface-based attenuation storage, effectively the SUDS basins, the 3 of them would store runoff, and they'd have a controlled outlet device, a controlled outflow, to restrict the rate at which water is released from those basins.
I think what I'm interested in, Dr. Telford, is whether or not the drainage, or certainly what members of the village may be interested in, is the drainage and the overland flow management scheme that you described. Does that result in elimination of downstream flooding? Is that the aim, or what does it do?
No. As I said, it's the proposals will not eliminate flooding downstream in Little Wymondley. As I said, the site forms a small part of the Ashbrook catchment, but it will contribute to a reduction in flooding in Little Wymondley. A modest reduction, but a reduction nonetheless. The overall, the analysis shows that there'd be something like a 14% reduction in peak runoff rates for the 1 in 30 event, with a reduction of between 3.5% and 5% for large events. So that's the betterment that the schemes would provide. So there is a significant betterment there, and that doesn't take into account the fact that the site is currently bare earth for part of the year as well. So
right, You've just described that as significant betterment. You give the statistics. You'll have heard Mr. Harding, I think, accept that that was marginal betterment.
Yeah.
So I just want to explore that a little
Mm.
bit. You work on lots of these schemes. Is it marginal or is it something more than that?
I think we're both right. It's significant betterment in terms of runoff coming from the site, but because the site only forms a relatively small part of the whole Ashbrook catchment, then ultimately the betterment within Little Wymondley itself will be marginal. And I think that's correct, but it will be betterment. There will be a betterment.
All right, fourth topic then. In terms of compliance with planning policy, we have a planning witness who will be dealing ultimately with questions of development plan and national policy guidance, but you obviously understand the background, you work within the framework of policy. So just taking it fairly shortly, do these proposals comply with policy in your area or not in your view?
Yes, I do. I mean, first and foremost, the site is located in flood zone 1, but it's greater than a hectare in extent. So as such, the planning application was accompanied by a site-specific flood risk assessment in accordance with paragraph 167 of the NPPF. The submitted FRA report, document CD6, assesses the main part of the site to be at low to negligible risk of flooding from all known sources. And as such, the development is in accordance with NPPF paragraph 159, which states that development should be directed away from areas of highest flood risk. The submitted evidence also demonstrates that the proposals would not increase flood risk elsewhere for the lifetime of the development in accordance with NPPF paragraph 167. So the proposals comply fully with national planning policy. In respect of local planning policy, and specifically the North Hertfordshire District Local Plan, CD 39, the site is located in flood zone 1 at a low to negligible risk of flooding from all known sources. It incorporates sustainable drainage systems and other appropriate measures that follow the drainage hierarchy. It was accompanied by a site-specific flood risk assessment prepared in accordance with national guidance and has been designed in such that flood risk is not increased elsewhere. And that all accords with policies SP11 and NE7 of the North Hertfordshire District Local Plan. The Wymondley Parish Neighbourhood Plan has 2 policies relating to flood risk, FR1 and FR2. Again, in respect of FR1, the application was accompanied by a site-specific flood risk assessment report and associated technical note that provide detailed information on the impacts of the proposals on flood risk, both on and off site, and demonstrate that the proposals would not increase flood risk elsewhere in accordance with that policy. The proposals also incorporate sustainable drainage systems, for example, these drainage basins I mentioned a moment ago, in accordance with policy FR2. So I conclude that, yes, the proposals do comply with national and local planning policy in respect to flood risk and drainage.
Okay, so that's topic 4. Then the 5th topic arises from Mr. Harding's point this morning, and that is in relation to the potential effect of trowel trenching, which is related to the archaeological written scheme of investigation. I don't know to what extent you've looked at that and how far we can take this, but let's have a look. It may be so that a note needs to come in, but let's see where we get. The written scheme of investigation is in the core documents,
Right.
and it's at CD 108, which is in folder 8.
So take it, which document?
So that
CD.
is CD 108. That is the archaeological mitigation strategy, the written scheme of investigation.
Mr. Hardy, can I just check the reference? Because I think previously we'd referred to CD 30.
I'm told it's in two places. I
Is it
think
the same
it's
document? Sure. Well, they've got different descriptions on the list. Without, I haven't opened them up to compare, but CD 108 is described as has a date of 2022.
May 22.
CD 30 is described as version 2, so it's obviously an update at some stage. But I'm sure we had CD 30 open,
Fine.
but I don't know whether it's the same document or not.
I don't know. It's a very simple point. I wonder, it might
Yeah.
not matter anyway. Let me ask the point, and then I'll certainly check to see whether they are the same. In methodology, so in CD 108, that's where I'm looking at the moment. There's a section 8 called trial trenching. That is on internal. They're very small page numbers stuck up at the bottom.
Yep.
It's internal page 12. So section 8 trial trenching. And you can see paragraph 8.5 on internal page 13. Says this: trenches will be excavated by machine down to the first significant archaeological horizon or to natural subsoil. See that?
Yeah.
And then in paragraph 8.7, you'll see that trenches will be machined to a maximum safe depth of 1.2 meters to allow access for hand excavation and recording. So it's a maximum depth of 1.2, but in practice, that might not be reached because you might reach an archaeological horizon, or indeed you might reach subsoil or natural bedrock. So that's the nature of the trenching. I want to understand whether you have looked at the trenching and the potential impact that might have on flood risk modelling, and whether you're able to give any evidence on that now, bearing in mind those details.
It's not something I've looked at. However, I mean, as long as the arisings are restored in the appropriate sequence, then there's sort of the actual flow regime shouldn't be disrupted. I think I can understand the concern. These are quite chunky trial trenches, aren't they? 50 meters long, I think you said, Mr. Harding. 1.8 meters wide. I'm trying to understand what the concern is here. Is the concern whilst the trenches are open that will affect the runoff, or is it that when they're reinstated?
I don't know. I suspect Mr. Harding will ask a question about it, but let me just deal with your evidence through you as far as we can take it.
Yeah.
And as I say, it may be a note that needs to come in, but that's 8.7.
Yeah.
In terms of what happens to the trenches, you can see at 8.20, which is on internal page 15. So once each trench has been fully recorded, trenches to be backfilled by a tracked excavator. Geotextile layer may be used to protect in situ archaeological deposits where appropriate. No specialised reinstatement will be undertaken. Trenches backfilled with trench arisings. First is subsoil if present before topsoil. It's then smoothed and dressed by excavator utilising tracks and bucket. Trial trenches will not be backfilled under archaeological supervision other than in areas of significant archaeological findings. So you have your trench, cord, if there's something that you might want to protect in situ, otherwise you backfill it. That's the...
and that effectively answers my own query. I think that is satisfactory as far as I'm concerned, and should mean that there shouldn't be an impact, a negative impact on the sort of the hydrological regime in that area.
Right. So I'm not sure whether that requires a note, whether or not precisely what the concern is. But so far as you're concerned, having read that WSI, your evidence is that makes no difference to the evidence that you've given in relation to risk or mitigation.
Correct. Yeah, I think that paragraph makes it clear.
Those are the 5 topics by way of amplification. Dr. Tilford, is there anything else you want to add? Otherwise, that is all I want to ask.
There's nothing else I wish to add. I know Mr. Harding raised one other point regarding land drains, but
yes, go on. No,
should
absolutely. Do you
I
want to do
pick
with
that
that?
up,
Yeah,
sir?
yeah.
It was regarding the metal posts, I think, the support posts for the solar panels. I think the number used, I scribbled it down, 32,000 metal posts. And based on the law of averages, there's a high probability that some of the existing land drains may be damaged. So again, this is not something that we've looked at in detail. All I can say is, I mean, you have to think about the purpose of those land drains. Those land drains will have been installed by the farmer to drain the fields, effectively to get water off those fields and out of the way. And what that means is those land drains effectively accelerate the movement of runoff from the site onto Priory Lane. So whilst I'm not suggesting that a conscious effort should be made to damage the land drains, if it would have any effect, it might actually be beneficial, ironically, in that it will prevent that free drainage from the site onto Priory Lane and into the Priory Lane drainage system. So I'm not trying to be flippant here, sir. I think that would be my understanding of it, frankly.
Good. Thank you very much, Dr. Tilford. That is evidence in chief, sir.
Thank you. Mr. Harding, questions for Dr. Tilford, please.
Yes, thank you very much, sir. And yeah, Dr. Tilford, I can assure you I'm not going to spend any time questioning your qualifications and capabilities. I couldn't even capture them all. So we're pleased to have you here. You have kindly answered some of the points. I might just come back on two items on that, but just tell me, in terms of the order, I think one of the key points you made about the runoff from the panels and the fact that it wouldn't create any variation would be that there is a good quality green lay grass, and that's kept maintained. Now, in terms of the construction process, does this grass go in first, and is it established before the posts and the panels go on, or afterwards? How do we make sure there isn't any short-term risk?
No, I mean, that's a very good point. My understanding is, and I hope I'm correct in saying this, that no, the site won't be grassland and then construction commences. There will be a period during construction where bare earth will be exposed. To address that, I think it's important, and I think this is something that is secured or will be secured ultimately by condition, should permission be granted. It's important that the mitigation measures that I've sort of outlined and presented in my proof of evidence, the surface water drainage basins and the flood storage basins, are constructed at the start so that they are there to retain runoff whilst construction commences and before grassland is established. So I think that's how, I don't think that's how it has to be addressed in my view. So you have that retention of runoff during the construction process.
Okay. How long do you think it will be till you've got a stable grassland that you feel comfortable with to operate as, if you like, normal?
Honestly, I don't think I can answer that question. I would have to take advice on that from.
Okay, we may come back to that one then with another expert. Yeah. Okay. We've added, and as you say, it's a belt and braces solution to have the flood storage areas, catchments, etc., in these vortex. So could you just explain, so we understand it, just how these vortex sort of system works? Is it natural? Is it automatic? Is it manual override and input? How exactly do we make sure this flow does not come out of those catchments when there is flooding down the lane or downstream?
Yeah, the outlet flow devices are proprietary devices. They are standard off-the-shelf devices. So if you want to Google it, HydroBrake, if you Google HydroBrake, you'll see such a device. They're not powered. There's no power involved. There are no moving parts. They simply have a device within them, and they sit within a shallow manhole, and they just control the rate at which the water passes through them, so that if you had a straight orifice, as the level of water increased, the rate at which water exited the pipe would increase. Effectively, the outlet control devices seek to limit that rate no matter how much, what the water level is upstream, if I can put it that way. They look simple, they're quite complicated in what they're achieving hydraulically, but they're a completely standard device which are used on every development these days up and down the country to restrict the rate at which runoff is passed forward or let out of the storage device. So they're just called outlet control devices, and there's a family of such devices, but no moving parts, no power, and the maintenance requirements they have to be maintained, inspected on a periodic basis, but generally they sort of look after themselves. I don't know whether that answers your question.
Okay, yeah, no, that's helpful to know. They're just an automatic process.
Yes.
Yeah, the other point was, I mean, thank you for giving us the background and in more detail in terms of the flooding problems we have. And I do think it's important to say we're not expecting you to this scheme to be flooding by solving the Ashbrook and Little Wymley flood problem, but you say it is of a major concern, and of course we are facing the addition just the other side of the high street of 312 or more houses that are likely to be developed, and certainly the whole flood risk issue, drainage, is going to be very much at the forefront of that, because that's a real additional pressure that will come on the high street. But the fact is that actually, irrespective of Ashbrook and the 5%, Priory Lane does flood. I know we have residents who have got factual information that they literally have to, if you walk up there and you walk up there regularly and you have these incidents over a period of time, you simply can't pass up Priory Lane. So Priory Lane in itself is a problem, and it would be encouraging to know that we can actually make some progress in helping that problem, because that is a key. This site is a very key part of what is coming down the Priory Lane. And do you feel that the scheme you've got will make a more than marginal difference to that problem?
To Priory Lane, yes, it would be more than marginal. It's when you go down further to Little Wymondley, you've got the additional effect of Ashbrook, then the benefit reduces because of the scale across the site. But yeah, I mean, the betterment percentages I cited in my evidence are designed to sort of provide the greatest betterment during the 1 in 30 year event. And that was an event specifically identified by the Leigh Local Flood Authority, I should say, who required betterment specifically for that event. The 2014 flood event, although the rainfall was estimated to have a return period of 1 in 2, so actually not that extreme rainfall in itself. As I mentioned, because the catchment was already saturated, the impact of that rainfall was equivalent to the 1 in 30 event. So, and as I've referenced, there's quite frequent flooding in Little Wymondley. So we're not talking about the 1 in 100 events causing flooding. It's actually relatively sort of smaller storm events can cause significant flooding in the district. So the proposals will provide significant betterment during the 1 in 30 event, that 15% betterment, and that will form, given that the site is almost not quite half of the Priory Lane catchment, there will be a significant benefit along Priory Lane for sure. Yeah.
Okay. Why is it then that you don't seem to be able to get the Leigh Flood Authority to sign off on this then? And it still seems to be they are still saying they have concerns and aren't finished with you, so to speak.
Yeah. Well, we could spend many hours discussing that point. I think, it's not my report, the feasibility report. What I can say is that McCloy Consortium, who did that feasibility or undertook that feasibility study, were looking at what measures could be taken to prevent flooding during the 1 in 100 event and the 1 in 100 event plus climate change. So how could you eliminate flooding in Little Wymondley? And that's a very different question and would require significant amounts of storage to actually provide that standard of protection, if I can call it that. And there would be issues just getting hold of the land to enable, that quantum of flood storage to be provided. So I think that's where they were coming at. We were looking at, this scheme is looking at reducing runoff principally during the 1 in 30 event, but not eliminating flooding. That's the point.
Yeah.
Two different things, really. And I know the costs in the back of the McCloy report are into the millions, 2.5 million, was it, of ballpark figure?
Yeah.
And that's only if you can secure the land in the first place. So I guess this scheme is doing something. It's, to improve matters.
Yeah. So how does that get reconciled then with the flood authority?
Can you expand?
In terms of this approval or this scheme, how do they? How does that get concluded? Yeah. I mean, have you got to do more to get them on side to sign it off, or is it just a matter of establishing their?
I think the proposals are now accepted by the lead local flood authority. We'll come on to this later, perhaps this afternoon, but conditions have now been discussed that will secure that betterment. So securement by condition is, I think, the answer to that question. The lead local flood authority will, of course, scrutinise our analysis to reassure themselves that we are, the betterment where we're stating will be delivered, and thereafter the actual schemes themselves, the mitigation measures will be secured by condition. That's, I believe, how it'll be secured in planning terms.
Yeah. Okay, fine. So final point, sir, is just back to these trenches, which I appreciate you can't have a complete view on, but as you say, they are very significant, 50 meters by 1.8 meter width, a huge amount of earth to be moved. And I think your point, I Catherine would not disagree with. If the earth goes back in exactly the same way that it came out, and it wasn't overly compressed, and it wasn't this, that, the other, it would be all right.
Yeah.
But you've got some pretty big machinery in there over quite a long time period, which presumably all happens before the start of construction, working in those fields. So there's compression, there's it would be a magic trick to get all that earth back in the same way. And we've got clay, and it's that in itself is going to go through land drains, which maybe it's a good thing. I don't know. That's another point. I mean, it does seem very significant. And having looked at it, I mean, do you have any concerns really about the extent of that work? Over 200 of them.
Yeah, my concern would be that they're reinstated appropriately. Now, as Mr. Hardy sort of steered me towards I can't recall the paragraph number. I think the key will be for them to be for the material to be reinstated properly, and that will require the appropriate working methods to be adopted. That the paragraph, forgive me, sir, I can't recall the paragraph number.
Yeah, no.
But there was reference to tracked vehicles. That in itself is a sort of a mitigation measure. You don't want JCBs with big tires going along, because then the soils will become compressed. So tracked vehicles can actually mitigate the impact in that respect.
Yeah.
Thereafter, as I say, it just becomes a factor of a requirement to restore those trenches in the right manner. But you know, it needs to be considered carefully, for sure.
And
Dr. Tilford, if for any reason they weren't restored in exactly the right manner, what is the risk?
I think the risks are not significant. You have to, understand that the site is poorly drained. I don't think anyone would disagree with that. We have, clay soils, it's impeded drainage naturally. So runoff does not really infiltrate into the ground a great deal. There will always be some infiltration, depending on the time of the year and depending on the antecedent conditions. But by and large, clay soils, rain hits the ground and runs off as overland flow. So I don't think the risks are huge. If anything, gosh, it might even improve drainage, who knows? But I wouldn't say the risks are significant, but I would think just out of almost on the matter of best practice, those trenches should be just reinstated as to reflect the pre-excavation nature as closely as possible.
Just thinking about the sequence, at that stage when the trenches were done, what would be the position with regard to the basins?
I don't know the timing of the trenches, I'm afraid, if Mr. Hardy could...
They happen at the outset. That's my understanding.
Okay.
For development starts on the solar farm.
Okay.
So if the trenches were to be excavated, not filled in properly, and you didn't have the basins to capture runoff, what are the implications?
I don't think the implications will be significant. As I said, I think you have to treat the site currently as being very poorly drained, reinstated along those trenches. There's not going to be a great deal of difference, frankly, based on the current soil type and the nature of the impeded drainage at the moment. We have clay soils there at the moment. Rainfall just runs straight across. I don't think that's something I'd be concerned about, frankly. I just think it would be good practice to ensure that those trenches are reinstated as close as possible to how they were prior to excavation. But I don't think it'll have any impact on overland flow generation.
okay. One last question, sir. Just on, and we talked about
Mr. Harding, that's two last questions.
Oh, it was the last one, the last question as well. Sorry. Yeah. Penultimate one then. The compression you mentioned, we're obviously trying to avoid compression. Do you have any concerns about the way in which the panels that are going to be placed on the 3 or 4 areas where they're not going to go in to the ground but be put on rafts?
In the sort of the no-dig areas.
Yeah, in the no-dig areas, yeah. So in terms of compression and your flow of water?
I think overall, overland flow will just make its way around the sort of, what are they? They're like concrete bases, aren't they? I think small concrete bases. But as long as we're not putting great structures in the way of the flow pathways, water will find its way downstream or downhill, as it invariably does. So I have no issues with that personally.
Okay. Well, thank you, Dr. Tilford. That's the end for me, sir. Yeah.
Thank you.
You may have questions. Just 2 points. One, I've looked, CD 30 and CD 108 are the same documents. They're just repeated. And the second thing is in relation to timescale, that's dealt with in the conditions that I know you've not yet seen, but they were in the previously agreed form, and that is that the development is condition 12 as it now is, the development shall take place in accordance with the programme of archaeological work set out in the approved WSI, and then no electricity to be exported to the grid until the site investigation has been completed in accordance with the programme set out in the approved WSI. So it was just on the point about the sequence of events that's to be set out in the WSI.
Dr. Tilford, I do have a few questions for you, but I just want to review those during the mid-session break. So we'll take that now. It's 11:30, so come back in 10 minutes, please. The inquiry is adjourned until 20 to 12. I think everybody's in the room for the restart. So could you all take your seats, please, and we'll get underway. Dr. Tilford, there's a few things I'd like to ask you about. First of all, I want to ask you about the part of the site which I think is in flood zone 3 on Stevenage Road. I think you say in your paragraph 4.5 that would be done in lengths of about 100 metres and would be backfilled the same day following the installation of the ducting. That's on page 7.
Yes.
Now, if that weren't the case, if it wasn't backfilled immediately, I'd like to know what the implication would be.
During a time of flooding. So,
Yes.
yeah. So I think the main concern there would be any spoil material that had been stored, which could be mobilized by the floodwater. So you could get sort of contamination of the runoff. I suppose the second consideration might be that barriers to the floodwater could be formed by the stored material, which could divert floodwater and potentially change the direction of the floodwater and could potentially increase flood risk. So I think there would be the two concerns. So.
Right. So the second one was it could change the direction of floodwater, potentially increase risk. So the first one was about contamination.
Yes, effectively, if you have soil stored, it could be washed away.
Yes.
Now that could have implications. It could block highway drains and so on. So I think there's a real consideration there, or a real impact potentially.
Right. The reason I ask that is that we heard from Mr. Kendall yesterday,
Okay.
In terms of highway matters, and his evidence was that he didn't anticipate that they would be backfilling immediately.
Okay.
That's it. That wouldn't be practical from the point of view of installing the cable connection. So how confident are you in terms of the evidence appears to be slightly contradictory in terms of what will happen with laying the connection. So given what Mr. Kendall said, can you be certain that the work on Stevenage Road will not cause an increased flood risk?
So there was no streaming yesterday, so I didn't hear what Mr. Kendall said under examination. As far as my statement goes, you referenced my paragraph 4.5. The advice I received was that the backfilling would occur on the same day. Now, if that's not the case, that wouldn't necessarily be a problem, but only if the excavation process, there was a sort of a flood warning plan in place so that no excavation actually took place if flooding was forecast. So I think practically that would be the measure I would recommend. I didn't recommend it because my understanding was the trenches would be backfilled on the same day. If that's not going to be possible in all circumstances, I think it would be prudent for the contractor to have a flood management plan in place as part of their construction management plan to stop the circumstances that I just mentioned occurring.
Yes. Presumably that would only work if there was sufficient confidence in that, in advance information about the risk of flooding.
That's correct. Yes. Now, I believe the area is in a flood warning area, so the Environment Agency will issue flood warnings.
Yes.
So a flood warning plan is only as good as the information
Yeah.
the processes respond to. So it would be, I'd agree with you. So it's important that, you know, the flood management plan effectively hangs off a forecasting, the Environment Agency flood warning system.
Yeah, but presuming that information is available, is it conceivable that there could nevertheless be heavy rainfall after work had been undertaken on the laying of the ducting?
I think it's conceivable, yes. I can't pretend it's not conceivable. I think it just comes down to sensible risk management on the part of the contractors.
Okay.
So I don't want to interrupt your questions, but I hope this is helpful, at least for a discussion that we might have this afternoon. So
Yes.
in one of the draft conditions for the construction management plan is proposed, there's one of the requirements would be confirmation that during installation of underground cables, no spoil or material should be stored adjacent Stevenage Road within the extent of flood zone 3. So that's a very limited point, but there's no the issues surrounding flood risk have at least been thought about for the construction management plan, and I see no reason why they can't be expanded into a sort of flood management plan of the sort that's being discussed. So
Yes.
it's in there already, but may need further work, and we can talk about that in the condition session.
I think to an extent that's right, Mr. Hardy. What I'm concerned about is that I don't think the evidence of Dr. Tilford and Mr. Kendall are entirely consistent in terms of what's happening along Stevenage Road. Now, I do want to be absolutely clear, given that's the area of flood zone 3, as to what the intention is. I'm not quite sure what the best way to deal with this is, bearing in mind that it's something that I anticipate. If you're going to suggest a note to deal with it, I think Jog may want to come back on this.
Yes, and that's also compounded, of course, by the difficulties in the fact yesterday wasn't streamed, so that Dr. Tilford didn't hear what Mr. Kendall had to say.
Yes.
So we've got that practical point. I wonder whether, I'm seeing your hands, but I wonder whether Dr. Tilford and Mr. Kendall need to speak, and then once Dr. Tilford's given his evidence, and I wonder then whether if a note came forward, I don't expect it to be very long, that might help to set out the position evidentially. But regardless, that does, I think, need to be carried through into a plan which is secured by condition in the construction management plan. The point I was just making was at least some thought has been given to that. The council and the applicant have considered that. I don't think that the provision that is proposed in what is now draft condition 4 goes far enough, but I think that can be expanded upon.
Okay, well, we'll certainly come to that this afternoon.
Yes.
Mr. Harding, do you want to comment?
Well, I think you make a very good point, sir. And yeah, there are obviously a number of utilities already in the road, and all that's got to be taken into account with the work as well. So, and of course, Stevenage Road, whilst wider, is a very busy road. So the method statements and the way it's all got to be done has got to be thought through extremely carefully. Yes. Yeah, I agree. As indeed has Priory Lane, because I think we moved yesterday from Priory Lane being sort of temporary traffic lights, etc., to an acceptance that it would probably have to have to be closed at times, and of course that's not flood area 3, but it has flood risks as well.
Well, let's park that for now, come back to it in the discussion this afternoon, but I do anticipate that John would want to comment on anything that may be
Absolutely. I
contained.
think there's two things there. So one, would you have any objection if a note came in from Dr. Tilford having spoken to Mr. Kendall? Clearly that can be commented on, but would that assist you?
I think I want to give some thought to that. I'll let you know later on, Mr. Hardy, about a note. Next thing, Dr. Tilford, is just about movement of water across the site. I think you said at an early stage in response to Mr. Hardy that the panels would be, the water would be able to move underneath the panels and also underneath the buildings. And I've got details of the buildings, and I think that's generally the case, but I just wanted to double check one of them, which is the switchgear building, which is CD20. I just want to know from you whether that is shown as being raised.
I must confess, I don't think I mentioned the switchgear building. Okay, so the switchgear building is CD20, if I'm correct.
It is, yes.
Yes, okay, I've got that now. It doesn't appear to be raised in the same way as the other
No.
buildings.
The others appear to have a
Correct.
clear gap below them.
And I don't know whether
That's there's a different notation
it is.
underneath the underneath the each of the elevations, which appears to show some. Well, I would have thought showed something solid.
That's what this drawing shows. So yes.
Right. So from what you've been able to see on that plan, does that indicate that water would not be able to flow under that building?
That would be correct. So.
And in terms of the solar panels themselves, we know that the majority of them are on poles. I think you were asked by Mr. Harding about the ones in the no-dig areas, which are on the concrete footings, and on CD15, we don't have a plan of them. We have side elevations. Do you know how the concrete footings are arranged? The reason I ask is that I was told previously in the inquiry that the rows would be continuous across the blocks that are shown on the general arrangement plan. What I'm interested to know is whether when they're installed in the no-dig areas, there would be continuity of concrete footings across that part of the site. If you can't answer,
I can't answer the question.
okay.
I don't know how he managed that, whether Mr. Hardy can.
Okay, well, we could
Interview.
perhaps somebody.
Take some instructions on
Things-
both the switchgear building
Yeah.
and on the concrete plinths. I've got Mr. Hoyle giving evidence, and over the weekend,
Yes.
we'll come back on that.
That's fine, Mr. Harding. But perhaps I will put this question to you, Dr. Tilford. If in the no-dig areas there was continuity between adjacent panels, of the concrete footings, would that impede water flow across those parts of the site?
If the concrete blocks are contiguous without a break,
Yes.
then that would impede the flow of water. So I'd suggest there should be some breaks to allow the runoff to pass through. But sir, I must say, it's not clear from the drawing whether
No.
there is
I understand that. That's
Yeah.
one of the reasons I asked
Yes.
you about it.
Yes.
But if there were continuity and there was and flow was impeded, as you mentioned, in relation to panels in those areas, and the position is as it appears to be in connection with the switchgear building, to what extent would that make a difference in terms of implications for runoff from the site?
I would have to review the location of these, the no dig areas. If perhaps, Mr. Hardy, if you could refer me to a plan which shows where the no dig areas actually are.
CD16.
I think so, CD16.
Yeah, that's right.
So
Okay. Okay, bearing in mind, I'm sort of looking at this for the first time. So as regards the southern area of the site,
Yes.
the panels are arranged sort of effectively downhill, if that makes sense. They sort of run east-west.
Yeah.
Does that make sense? Which is the same as the overland flow pathway. So actually, in that instance, even if the concrete blocks were contiguous, runoff would be uninterrupted effectively, because it would flow down between those lines of panels as it currently does. So just based on this drawing, my view would be that actually on that southern part of the site, there would be no significant impact. However, that's not quite the same for the panels in the northern part of the site, because the flow pathway there is there is a flow pathway which runs sort of north in a southwesterly direction across there. Now, actually, in that part of the site, the actual flow regime is also east to west. I think it would have limited effect in that instance as well, actually, because I mentioned a valley that goes across the northwestern part of the site. The
Yes.
runoff would effectively run through the lines of panels, and thereafter it would continue in a southwesterly direction. They're not really blocking the flow pathways off, sir, actually, in either instance. So whilst they may subtly alter the flow regime, I don't think that impact is going to be significant. The overland flow is not completely obstructed. So it will continue to go where it would have gone before, albeit in a slightly amended
Yes.
route.
Yeah.
That would be my thought on that. So I don't think perhaps it's such a significant issue. However, if it's possible to break up those concrete blocks to at least provide some gaps, I don't know whether that's feasible. I'd have to take instruction, but that would be beneficial. But even if that isn't done, I think that there wouldn't be any significant impact on flood risk.
Okay.
Certainly not offsite.
Sir, I'm very hesitant because obviously I can't give evidence, but we've got Dr. Tilford here. And I wonder whether or not I can make a a factual observation just to make sure that we are getting at the right evidence. It's in relation to the how the concrete skids work. They run perpendicular to the row. So on the drawing, so if you look at CD 15,
I've got this in front of me, yes.
so the row goes across, but the skid will run it effectively at 90 degrees. So
But how can I tell that without the plan, without a plan for the base?
maybe we need to put another plan in. That is how they work factually. So they're on you've got the posts, the skids, and then you have the panel mounted on them. That's how they operate. If there needs to be another drawing given so that you can see it from effectively behind.
All I've got is a sideways view of the panel.
Yes.
I haven't got the other elevation,
Yes.
and I haven't got a plan which shows how they're positioned on the ground.
Absolutely understand that. So factually, that's how it works. But if another plan is required or drawing is required to show that, then one can be prepared, or even a photograph of a typical panel might do. But just in terms of asking of the evidence, I don't want Dr. Tilford to be absolutely, you asked very sensible questions, but of course, but don't want him to give evidence on the assumption that the base is a contiguous row running with in parallel with the row. It actually runs perpendicular to the row. So actually, I don't know whether that changes the evidence, but that is how those panels will work.
A photograph of a typical panel may
Do.
may deal with Mr. Hardy rather than getting
Right.
one drawn up, especially. But it is information that I think would be useful.
Yes.
It isn't in at the moment, and would have been helpful earlier, I think.
Yes, I have to say, I mean, for everybody, panels, that's how they are. But I agree, it's not shown on the plan. I don't know whether that alters Dr. Tilford's evidence, because he seemed to be giving evidence on the basis that it was a solid base that was running in
Well, that was
parallel.
because that was a scenario I put to him.
Yes,
But he did go on to qualify his answer in any event. If the position were as Mr. Hardy's indicated it could be, and we haven't seen such a document yet, would that make any difference?
I think, like you said, I just need to see to understand better the proposals there
Yes.
before I comment further, if I may take that approach.
Okay, thanks. I want to ask you about the runoff rates, which you've told us would be restricted. You were explaining the mechanism to Mr. Harding. And in your proof, got some information on this I don't know, it's on page 14. You've got two tables.
Yes.
And I also want to go to, I think it's CD 31. Just try that. I've got a note about page 5 of CD 31.
Yes.
You've got it. Right. Table 2, page 5 of CD 31 gives the natural amount, doesn't it? In your proof, you're talking about percentage reductions.
Yes.
Can you just, is it possible to relate table 1 in your proof to table 2? So,
To table 2 in CD 31.
yeah, so that I know
It's not, sir.
it's not a straight read across. No.
But it can't. It's for two different schemes,
Yes.
effectively. The data presented, or the analysis presented in table 2 of CD 31 is for a scheme that has subsequently been modified. Let me put that another way. The evidence presented in my proof of evidence is for an amended drainage scheme. So as a result of some of the commentary, well, we did some additional work effectively to address what we thought were going to be some planning conditions. So the drainage scheme developed.
CD 31 in itself was an amendment, wasn't it?
It was, yeah.
Yes.
Yeah. So that was effectively the first go at a drainage scheme or an overland flow management scheme. Okay, that was subsequently amended, and the result and the analysis for the amended scheme are presented in my proof of evidence. You can't compare the two. So one of the key amendments was the introduction of an additional flood storage basin.
Yes, I was going to ask you about that
Yes.
because there's reference to 2 in CD 31 and 3
And
3
that's
in
the
yours.
point. That's the point of difference, sir, which is why
Right.
you can't compare the two. In my the betterment that I articulate in the proof of evidence is different.
Although you refer to CD 31, then has it in effect been superseded?
The scheme has been amended, so the analysis is superseded. Yes.
So should I disregard CD 31 entirely? Is it just a historic document showing the progression of the scheme?
It is. I think it's working. It was work in progress always. So I would steer you to the scheme that is described in the proof of evidence in CD 163, my proof of evidence. Yes. Sir.
And in your proof on page 14 of the 2 tables, is table 1 the one that would have the most significance because table 2 is simply looking at the worst case scenario?
Table 1, correct, sir. And may I say, table 2, I've in the title it says worst case.
Yes.
It's not really a case because the site will not be bare earth.
Yes.
So I don't want you to think that there's an option that it
Yes.
may be bare earth. And that's why I explained that the scheme was developed to provide betterment even in a sort of a worst case scenario, which in reality won't exist. So the key table is table 1. What table 2 is demonstrating is even if the panelled site was bare earth, there would still be betterment during the 1 in 30 event, albeit a minor sort of 1%, 2%, up
Yes.
to 3% increase in runoff rates for some of the larger events. But that's not a real scenario.
No, the appropriate point of reference is table 1.
Yes, sir.
Okay. I think you've partly answered my next question, which was going to be about the basins and the changes in numbers.
Yeah.
I also had a question about how they should be referred to, because there's different terminology, which I think between, well, CD 31 I could perhaps put to one side, but there's different terminology there, I think, in your proof and also on the plans. And just from the point of view of referring to them,
Okay.
understanding whether there are any differences. For example, on core document 16, which is the general arrangement for the site overall, that refers to surface water attenuation basins and surface water detention basins. And I think I've come across a third term as well, but these are effectively doing the same thing on holding water and restricting the rate at which it leaves the site?
They are all temporarily storing runoff.
Yes.
Yes. So the key point to note is that there are 3 surface water attenuation basins. Maybe that's how they're best referred to. Surface water attenuation basins. They are there to store runoff generated from the access tracks in the areas of hard standing. They're the surface water attenuation basins. 3 of those, 1 in the northern area, 2 in the southern area. There are then 3 flood storage attenuation basins or flood storage basins, which are designed to store runoff from the panelled part of the site.
Why the difference in name?
I can only apologise for the inconsistency. There's no single name that these are referred to within my area, so different people tend to refer to them in different ways. I can only apologise for my own inconsistency, but I think the best way to refer to them would be surface water attenuation basins and flood storage attenuation basins.
And flood storage, that's
I don't know whether that helps you or not.
no, I think that's a third name you just come up with. And they're all doing the same job.
They're all doing the same job.
Does it make any difference?
No, they're just managing runoff, generating it from a different
Yes.
place.
Yeah.
They're all attenuation basins. You have 6 attenuation basins. So.
I think the last question is you've put in an Annex A to your proof, shows the surface water drainage and overland flow management scheme and a series of plans.
Yeah.
Is there a composite available, or is this the only way in which it can be seen?
So in my proof, I think I've split the drawing down into 5 pages.
6.
Is that 6? Is it?
Thank you.
And I have prepared a single drawing.
Okay, that's all.
Showing everything, but I haven't submitted it in my evidence. But I do have one with me now, albeit on A4. The problem is when you try and represent the entire
Yes.
site on an A4 drawing,
Yeah.
it becomes difficult to make things out. But there is a single 1-page drawing available. So if that would help.
It may just be useful as a reference to make sure that the different parts are in the right order and how they fit together.
Understood.
So that can come in some time.
Okay.
But
Yeah.
the Annex A is the latest one as far as the drainage is concerned.
Sorry, I beg your pardon.
Annex A is the latest one as far as the drainage is concerned.
Yes, that's correct. Yeah.
I think it just, again, going back to Mr. Kendall from yesterday, I think the second sheet shows an old access arrangement. But I don't know if that makes any difference in terms of what you've taken into account in terms of where runoff would go.
Again, difficult for me to comment because I didn't see Mr. Kendall's.
But simply the access is in the wrong place. If you look at the second of the, have you got the A3 sheets as well?
I'm referring to Annex A of my proof. Is
Yeah.
that correct, please? Yes.
So the second one shows the northern parcel.
Yes.
And as you move along from west to east, you come to the access point,
Okay.
which is more or less coming down in a straight line. Whereas it actually moves over to the east.
Okay, that's the second page you're looking at there. So is that correct?
Yes, it is.
I understand. Yes. Any shift in that access, I'm not aware of one, I apologise, but it wouldn't change the drainage arrangements per
No.
se.
Right, thanks. You,
Okay.
Mr. Hardy.
Thank you, sir.
So, Staley, were you? No. Mr. Hardy.
Nothing I need to clarify. I think the note, if that is something you could come back on, so as to-
Yes.
we found some photographs now. I don't know whether we'll perhaps get those printed of the skids.
Okay.
They're just of a standard design, so we perhaps get those printed off at lunch and distribute.
Yes, I'd like Mr. Harding to see them as
Yes.
at an early stage. Thank you.
Thank you, sir.
Thank you.
Thank you.
We've gone to your witness at last. Just while Dr. Tilford's packing up, Staley, how long do you estimate for evidence in chief from Mr. Robinson?
I'd hope about 45 minutes.
So that would take us up to lunch.
I would have thought so.
Yeah. Okay.
Just in terms of documents, sir, for the evidence in chief,
Yes.
all you'll need is the summary proof at CD 172 and the main proof at CD 173. And then the district local plan at CD 39A and the MPPF.
Yes.
And the MPPF should be in folder 6.
You're going to ask Mr. Robinson to read his summary? Yes?
Yeah, I am.
Yeah.
Unless there's any objection from you, sir, I was just going to
No.
follow the same approach
No,
that the
that's fine.
applicant has. Are you ready, Mr. Robinson?
Yes, thank you.
Sir, are you happy for
Yes,
me to begin?
Yes, I've got everything I think you've mentioned.
Good. Okay. So you are Michael Robinson and you hold a Bachelor of Arts honours degree. And here we're just in your main proof of evidence, looking at your qualifications from paragraph 1.1. You tell us you've got a Bachelor of Arts honours degree in English Literature and Geography from Keele University. You also hold a postgraduate diploma in town planning from the University of Westminster, and you're a member of the Royal Town Planning Institute. You are a planning consultant providing planning consultancy services for public and private clients, and you have over 35 years of planning experience in both the public and private sectors. And over this period, you've advised on numerous development proposals in the context of planning applications, development plan preparation, and appeals. You also tell us you received instructions to act on behalf of North Hertfordshire District Council in respect of the Colin inquiry in early July of this year, And before that, you had no involvement with the application. Is that all correct?
That is correct.
Good. Can I then ask you please to read your summary proof? You can skip out the first section, so please just read from section 2.
Thank you. I hope everyone can hear. My evidence addresses main matters identified by the inspector, including the following: consideration of the development plan, including assessment of Greenbelt policy and impacts, whether the proposal would represent inappropriate development in the Greenbelt, the effect of the proposed development on the openness of the Greenbelt, the implications of the proposal for meeting the challenge of climate change, the effect of the proposal on the character and appearance of the area, whether the proposed development would be consistent with the development plan and other relevant policies, whether the harm to the Greenbelt by reason of inappropriateness and any other harm would be clearly outweighed by other considerations so as to amount to the very special circumstances necessary to justify the development. At section 3, I turn to Greenbelt policy and impacts. In terms of impacts, sorry, I'll start that again. Greenbelt policy and impacts of the proposal on the Greenbelt. And I consider these issues in section 6 of my proof. We've heard this before, but it is common ground that the proposal comprises inappropriate development in the Greenbelt, which is by definition harmful to the Greenbelt. Such development should not be approved except in very special circumstances, which will only exist if the harm to the Greenbelt by its inappropriateness and any other harm is clearly outweighed by other considerations. In my evidence, I review and analyse the applicants' and the local planning authorities' assessments of the effects of the development on the openness of the Greenbelt and the purposes for including land within the Greenbelt. I conclude in paragraph 6.33 of my proof that the proposal would be inappropriate within the Greenbelt and there would be significant harm to the openness of the Greenbelt, both spatially and visually. And in my judgment, there would be limited harm to purposes A, which is to check the unrestricted sprawl of large built-up areas, and B, to prevent neighbouring towns merging into one another, and significant harm to purpose C of the Greenbelt, to assist in safeguarding the countryside from encroachment. I acknowledge that these impacts on the Greenbelt would not be permanent. In section 4, I refer to character and appearance of the area. I consider the effects of the proposal on the landscape, character and the appearance of the area. Sorry, at section 7 of my proof. For professional analysis of the landscape visual impact assessment accompanying the application, I rely upon advice contained in the landscape and visual review documents produced by the Council's landscape consultant, a company known as the Landscape Partnership. Those documents are core documents 86A and 86B. I do agree with the Council's consultant's review where it says there would inevitably be adverse impacts on landscape character and appearance. I also consider that the adverse impacts would be localised and the mitigation proposed would be beneficial and would reduce the adverse impacts on landscape character and appearance. I consider that ultimately, with the site's decommissioning, the planting proposed would result in improvements to the landscape character and appearance of the area that without the proposal might not otherwise be achieved. In terms of climate change, I consider the implications of the proposal for meeting the challenge of climate change at section 8 of my proof. I acknowledge the urgent and pressing need for the rollout of renewable power generation schemes of all kinds and the very substantial benefits of the proposal in terms of renewable energy production and its role in addressing the challenge of climate change. I note the local and national in-principle policy support for renewable and low-carbon energy development in appropriate locations, and the declaration of both national and local climate emergencies, and the drive towards achieving net carbon zero in the UK by the year 2050, and in the North Hertfordshire district by the year 2040. In terms of heritage impacts and heritage balance, I consider those impacts and the balance at section 9 of my proof. In my opinion, the impacts of the proposal on the setting of heritage assets in the area is less than substantial and at the lower end of the spectrum of a less than substantial harm. I note that my assessment of heritage impact accords with the conclusions of others, including that of Historic England. I also consider the impacts upon potential archaeological features of the area and conclude that planning conditions would be necessary to allow for the proper investigation and recording of archaeological evidence and finds in accordance with current advice and best practice. In respect of natural environment, I consider impacts on the conservation and enhancement of the natural environment at section 10 of my proof. In my analysis, I conclude that the land will not be lost to agriculture and that the landscape planting and future management of the site as an operational solar farm as proposed would mean the proposal would result in net gains to biodiversity and new habitat creation. Turning to drainage, at section 11 of my proof, I consider the issue of site drainage, and on the advice of the local lead flood authority, I conclude that improvements to the local surface water drainage conditions can be secured through the imposition of suitable planning conditions. On other matters, at section 12 of my proof, I consider other matters relevant to the proposal, including highway and noise impacts during the construction, operational and decommissioning phases of the proposal, and the creation of permissive rights of way passing through the site for the duration of the proposal. I conclude that the highway and noise impacts are not significant and can be controlled by planning conditions, and that the provision of new permissive footpaths through the development site, totaling several hundred metres in length, would be a benefit to the area. Conclusions and the planning balance. In section 13 of my proof, I seek to identify those matters that weigh in favour of and against the proposal, and to apportion the weight to be afforded to benefits and harm. In accordance with paragraph 202 of the NPPF, I weigh the less than substantial harm to designated heritage assets against the public benefits of the proposal, and come to the conclusion that the benefits outweigh the heritage harm. In my assessment, when taken together, I consider the benefits of the proposal clearly outweigh the harm that has been identified to the Greenbelt and the other harm that has been identified, such that very special circumstances exist. And in section 14 of my proof, I conclude that except for some conflict with North Herts Local Plan Policy NE2 and Wymondley Neighbourhood Plan Policy GB1 in relation to landscape and Greenbelt, I consider the proposal accords with the other development plan policies, both in the local plan and the Wymondley Neighbourhood Plan, that are relevant to the determination of the application. Thank you.
Thank you very much, Mr. Robinson. Now we've got 5 areas of focus. The first one I'd like to deal with is Greenbelt, and you deal with that in your main proof of evidence, so CD 173 in section 6, pages 7 to 14. Just a preliminary couple of points, first of all. You refer to the council's Greenbelt review that was undertaken to support the local plan. In the core documents, I don't think we need to turn them up. We've got a Greenbelt review from 2016 at CD 143, and then an update in 2018 at CD 135. Could you just assist with why an update was undertaken to that review?
Yes, I can. As is normal practice for local plan preparations for areas which may have greenbelt within them, an assessment of the performance of greenbelt areas was carried out in 2016. In 2018, partly I think as a result of some criticism levelled at the methodology applied to the original document as a result of the local plan examination, and also partly in response to case law. I think it was the Sam Smith case. An exercise was undertaken to reinforce the assessment of greenbelt parcels and sub-parcels, taking into account the very latest advice of the courts. And as a consequence, certain areas specifically or principally aimed at the proposed local plan allocations and the parcels affected by those allocations was undertaken. I think it's fair to say, though, that in the context of the site that we're looking at today, that the review document did not substantially, or indeed, I think at all, alter the findings of the 2016 review. But for completeness, sir, that is the explanation.
Thank you very much. And the relevant parcels and sub-parcels that the application site sits in are 10 and 14 and 10C and 14F. Now, I wonder if you could just provide the inspector with the references, the page numbers within the two review documents, if he wants to go and look at the way in which those parcels were considered. Yes,
you'll appreciate it's quite a sizable document, but as an aid to navigating the document, when looking at the Greenbelt review from 2016, which I believe is CD core document 143, there's a range of information. Yes, parcels 10, strategic parcels 10 and 14 are identified on a map found at page 31 of the document. That map shows the areas colour-coded in terms of their perceived contribution to the Greenbelt. Later in the document, as a result of assessing subparcels, smaller areas of land, parcel 10 for Little Wymondley appears on page 45. Subparcel 10C, the more refined assessment of the smaller subparcel, at page 46. Parcel 14, the William larger parcel, is dealt with at page 51, and parcel 14F, the smaller subparcel, at page 52. Thank you.
Thank you. Moving on then to the issue of the impact of the application on the openness of the Greenbelt, and you deal with that at paragraph 6.28 to 6.33 of your main proof of evidence. Now, you heard what Mr. Mason had to say yesterday in evidence regarding his views as to the impact of on the openness. I'd like you please just to summarise the view that you take.
I will. In terms of openness, my comments, of course, stretch over a number of pages, but in my proof, But in summary, I will remind you that my assessment relates to both spatial elements and visual or perception elements. Spatially, the development is introduced into an area of land where there is currently no development. And so, although one might debate the extent of the spatial effect, there's no doubt in my mind that the openness of the Greenbelt will be diminished in spatial terms. I can qualify that by saying that I recognise that there would still be open areas between and below the solar panels and within buffer zones and access routes throughout the development. But I maintain that in a spatial sense, there would be a loss of spatial openness. Visually, and this I think is a point brought to the forefront by the JOG group, of course, there will be a visual impact upon the perceived openness of the locality when it is viewed from, in my view, principally an intermittent range of views located around the site. I do also acknowledge that the landscape visual impact assessment and the council's consultants' opinions, the visual impacts will, I believe, in time be mitigated by the landscaping proposed, and it will be absorbed to an extent into the wider landscape. And of course, after the operation of the solar farm ceases, the development will be removed from the site, leaving the land in much the condition that it appears at present. I think that my assessment there differs to some degree to each of the professionals that have contributed thus far, but I maintain that it's probably in broad alignment with many of the views that have been expressed to date and which appeared in the Council's committee report from November of last year. Thank you.
Good, thank you. And then yesterday, and in his written evidence, Mr. Kendall provided a view in relation to transport-related Greenbelt harm. Now, your evidence doesn't disaggregate the harm into different sources, but I'd like to understand your view on transport-related Greenbelt harm. So Mr. Kendall referred to vehicle movements, the access into the site and the temporary passing place.
Yes, you're quite right. I don't specifically refer to Greenbelt impacts arising from transport and highway matters. And the reason for that, I think, is that I didn't consider that they were at all substantial. Whilst inevitably during the construction phase in particular, there will be some comings and goings of vehicles, and they may be perceived over a temporary period as being significant. I think I heard from the evidence of yesterday, however, that the number of vehicles averaged over an hour, for example, even during the construction period, is likely, I think, to have a relatively low impact upon the Greenbelt in the area. And of course, that construction period is relatively short. I think the period of 36 weeks has been mentioned. After that, again, the likely impact of vehicle movements and of vehicles being present on the site and in the vicinity of the site and associated with the solar farm is likely to be really very much lower. Those are the reasons why, frankly, I did not, in drafting my proof, consider highway and transport matters to be at all significant, but in terms of completeness, that really would be my thoughts on the matter.
Thank you very much. Let's move on then to impact on the purposes of the Greenbelt. So as you set out in your summary, you've identified harm in relation to three purposes, purposes A, B, and C. Let's start with purpose A. You deal with that at paragraph 6.21 to 6.22 of your proof. So checking the unrestricted sprawl of built up areas, and you've attributed limited harm. Just explain why that is, please.
Thank you. In my view, the fields affected by the development form part of a wider area of undeveloped land located between settlements, including Gravely, of course, Great Wymondley, and the larger settlements of Stevenage, Hitchin, and Letchworth. That wider area, and indeed the smaller area comprising the application site, contribute towards the gap between those settlements. And I consider that the case despite the urbanizing influence of infrastructure features such as the A1 motorway and the mainline railway, which has been discussed before. So, as part of a wider open space, an undeveloped open space, I do consider that it plays its part in preventing urban sprawl. I would say also, however, that the site, in my experience, and I have visited the site personally on 2 occasions, and seen it from both within and outside of its confines, I don't consider the site is widely visible. And its visibility, furthermore, will reduce in time as the proposed mitigation of landscaping matures. But I'll reiterate that its current undeveloped nature does assist in checking the expansion or the sprawl of surrounding urban areas. But in my assessment, the size of the site and its position and topography means it has a relatively limited adverse effect upon that purpose of the Greenbelt.
Good, okay.
I'd just like to come in, Ms. Daly. Mr. Robinson, in terms of that purpose and the reference to sprawl of large built-up areas, just want to be absolutely clear about your understanding of what those large built-up areas are, bearing in mind what Mr. Griffiths said in evidence to the inquiry.
Thank you, sir. Yesterday was an education. I do not have the benefit of Mr. Griffiths' long experience of Greenbelt and its evolution in Hertfordshire. So I have no question to doubt the original intention of Greenbelt, and indeed it makes a great deal of sense in retrospect. In my assessment, as a younger planner, I think I tend to take the view that Mr. Griffiths referred to, perhaps an emerging view. My initial thoughts on the larger built-up areas affected by Greenbelt were those areas comprising of the larger towns around Stevenage, Hitchin, and Letchworth. Although relatively modest towns on their own scale, they are the largest urban settlements in the vicinity of the site. In terms of the impact, direct impacts upon those towns, I would concede that the impacts or the effects in terms of checking sprawl of those towns is relatively limited. And I think that led to my judgment concluding that they would have the development of this site would have a relatively limited adverse effect upon the purpose of Greenbelt A.
Thank you, Mr. Robinson. Moving on then to purpose B, to prevent neighbouring towns merging into one another. Again, you identify limited harm. That's set out at para 6.23 of your proof. Just a summary of your view, please.
In summary, my comments are really quite similar to those with respect to purpose A, to prevent the merging of towns. In my view, the quantum, clearly, if the site were to be developed as proposed, the quantum of undeveloped land between the towns that I mentioned previously would potentially reduce. Perhaps not potentially. It would reduce. And in my view, land need not be immediately contiguous to a settlement or its boundaries to extend the influence of that town or urban area. I can think of many towns, for example, which might have quite substantial open areas, dividing areas of built form, but would still fall within the same town boundary. So the mere fact that it does not immediately adjoin or abut the adjoining town, the nearest town of Stevenage, for example, in my view, does not mean that that it has no purpose or function in providing a separation between towns and villages. And that so is why my conclusion on Greenbelt purpose B was that it would have an adverse effect, but that effect would be limited.
Thank you very much. Moving on to purpose C, to assist in safeguarding the countryside from encroachment. You identify significant harm at paragraph 6.24 of your proof. An explanation of that, please.
This in many ways, I think, is an easier explanation. Currently, the site comprises open fields, and as a result of the proposal, development would be introduced into those fields. And that results in land currently devoid of built development being occupied by a form of built development. So I think it's inevitable that there would be harm resulting to purpose C. And I think also the council in its assessment quantified that harm as being significant. Thank you.
Good. And then one small final point in relation to Greenbelt matters. There was some discussion yesterday in Mr. Griffith's evidence regarding the additions made to the Greenbelt by the North Hearts local plan. It's not set out in the plan itself, but do you have an idea of the scale of additional land that was added to the Greenbelt by the local plan?
I do, sir. For the inspector's benefit, I think we saw a plan yesterday which very usefully illustrated the addition in plan form, but in the course of our preparation for this inquiry, I have found an email produced by the council's planning policy manager, which answered this very question in the context of the local plan inquiry. In broad terms, I understand the additional area of Greenbelt within the district amounts to approximately 4,000 hectares. And to put things into scale and context, that has resulted in the area of Greenbelt land in the district rising from approximately 38% of the district's total area to around about 47% of the district's area. So that's a substantial increase in the overall area of the green belt across the district. Thank you, sir.
Sterling. Sorry to interrupt. I just want to understand the additional 4,000 hectares. Is that the contribution from the additional allocation, or is it a net change?
That is a net change, sir.
So presumably there was more than 4,000.
There was, but as I think was made clear by Mr. Griffiths in his evidence, there was land, of course, removed from the Greenbelt, principally in connection with some strategic allocations. I think some boundaries around inset villages and settlements within the Greenbelt were revised. And the net result is approximately 4,000 additional hectares.
Moving on then to our second topic, and the rest are a bit shorter. Landscape character and visual impact. You deal with that at section 7 of your proof, pages 14 to 20. Now, bearing in mind, you're obviously not a member of the Landscape Institute. Landscape matters aren't your professional area of professional expertise. And yesterday we heard from Mr. Mason that he considered that the conclusions of the Landscape Partnership, acting on behalf of the council and the applicant, were, with some small differences, broadly consistent. Could I ask you just to summarise what you understand the points of distinction to be between the council's position and the applicant's position in relation to, firstly, landscape character?
I'm sorry, could you repeat the final part of that question?
So I'm asking you to please summarise what you see as the differences between your view or the council's view and the applicant's view regarding the impact of the proposal on landscape character.
Right, yeah. Well, again, I think in a sense, I'll be repeating something which I think it was Mr. Mason said yesterday. There are differences, although I'll make it clear, I'm not a landscape professional, but I have read and assessed both the applicant's analysis and conclusions, the council's own analysis and conclusions, and I've applied my own judgment also. And I think it's clear that whilst there are differences in the degree of impact, the level of harm or difference, that in broad terms, we're actually on quite a similar page. I, having assessed both the applicant's appraisal and the review by the council's landscape consultants, I too came to essentially the same conclusion as was expressed by Mr. Mason yesterday, and which I think was usefully illustrated in the table produced by Mr. Mason, which refers to the Landscape Partnership's table of differences. If you recall, I think the differences were identified in a yellowy colour on that table. The council's landscape consultant, where differences were achieved, the council's landscape consultant tended to identify a slightly higher level of harm and impact than the applicant's view. But those differences, as I think Mr. Mason made clear, were within the normal realms of professional judgment. There were no very substantial changes or differences of opinion between those landscape professionals. And having read and assessed both of those and given thought to it myself, and indeed walked the site and considered those factors in my own mind, I tend to agree, and I think I expressed this in my proof, I tend to agree with the slightly higher level of harm that was identified by the council's consultants.
Good. And I think your answer there was referring to both landscape character and visual impact matters. Is that? I just want to
Yes.
clarify that. Yeah. Fine.
Yeah, I mean, I could elaborate on that. In terms of character, what I perceive as character, and I think this stems from the professional input, are those parts, characteristics of the landscape that form its character, the presence of hedgerows, the presence of small copses of trees. Those form the framework or skeleton of the character of the area. The visual impact, of course, is how users, people living locally, people visiting the area, will actually perceive the landscape. So those two elements come through once again.
Good, thank you very much. Just a policy point here. Can I ask you to turn up policy NE2 of the local plan? It's at page 150. Now, Mr. Mason's evidence yesterday was that he considered there to be no conflict, that the proposal would not conflict with policy NE2. In your proof, you explained that you do identify some conflict. Can I ask you please to explain your view as to the nature of that conflict?
Yes, and I'll go back to the words I spoke just a few moments ago. If we look at policy NE2, you'll see that it's a permissive policy suggesting that planning permission will be granted for development proposals that, and then there follows 4 criteria. Criteria A requires developments to respect the sensitivities of the relevant landscape character area. And a few moments ago, I remarked upon what I regard as character elements, the presence of field boundary hedgerows, and the presence of tree copses and landscape features of that nature. And the development proposal, of course, proposes the retention of each of those features. Existing hedgerows are remaining. There are no trees or copses to be removed as a result of the development. Indeed, they're to be protected during the course of development to prevent any possibility of accidental damage. Furthermore, the landscaping proposed, the mitigation, actually seeks to reinforce and strengthen those landscape features. Where there are gaps in hedgerow boundary, field boundaries, as there are in places, then those hedgerows are to be planted up and gaps filled. There are small copses of trees proposed, for example, around the entrance to the northern parcel. And I suppose more significantly, there are much of the entire boundary of the solar farm is to be planted. That planting, as I understand it, is to be in the region of 12 meters deep, which is actually double that was initially proposed, and which came about, of course, as a result of the council's landscape consultants' recommendations. And I'm pleased to see that those recommendations were taken on board. And I would agree with what Mr. Mason said yesterday. I think as a result of those changes, we have a better scheme, and one which will do more to mitigate the impacts of the development upon the local area, and which will see improvements to biodiversity. Turning to point B of policy, to not cause unacceptable harm to the character and appearance of the surrounding area. This, I think, is the key area of my concern, and why I say in my proof that there is an element of harm to policy NE2. I think the introduction of solar panels, perhaps certainly of this scale of coverage, will inevitably have an impact upon the appearance of the area. Whilst much can be done to mitigate the views of the solar panels over a period of time, I think that there's no doubting that they will have an impact that extends a little beyond the boundaries of the site. I think the council's landscape consultants were of the view that the impacts of the development would spread, several hundred meters in each direction potentially. So that really is the area of criticism and conflict with policy that I've identified. But for completeness, I'll go to point C of the policy, which requires that the development proposals are designed and located to ensure the health and future retention of important landscape features. As I said at the start of my answer, the landscape features on this site are all to be preserved. They are not going to be affected directly by the development in any way. And finally, point D, the requirement is to consider the long-term management and maintenance of any existing and proposed landscape. And I think there's a clear commitment within the applicant's case, and which can be secured by conditions, to see that both the existing landscape features, the hedgerow field boundaries and planted trees and so on, together with the new landscaping, will be managed and looked after for the duration of the development's presence on site. Thank you.
Good. Okay, thank you. Then just keep the local plan open. We're moving on to a new topic, which is just a few short points on renewable energy policy. Policy NE12 of the local plan at page 166. This is the policy on renewable and low carbon energy development. Just a very short point. Now, yesterday, Mr. Griffiths was asked about this policy, and he accepted that where one is dealing with a proposal for a solar farm involving the best and most versatile agricultural land, that proposals will be determined in accordance with national policy, and therefore the rest of that policy, NE12, wouldn't strictly apply. I just wanted to understand whether that was consistent with your view of the interpretation of that policy.
Yes, it is. Yes.
Good, thank you. And then we'll move on now to the NPPF. Just another short question in relation to the amended paragraph 155. Are you looking at that in hard copy, Mr. Robinson?
I am looking at it in hard copy.
So I understand, and someone to my right will correct me if I've got this wrong, that the start of that document is the revision made to the relevant paragraphs, which include 155. And then following that, there's a copy of the 2021 NPPF.
Yes, that's correct. The first 3 pages include some text in blue print, which
Okay.
I think is the updated version.
Okay, I just wanted to make sure we were both looking at the right paragraph.
Yeah.
Now, we know paragraph 155 has changed in the last week. That paragraph starts to help increase the use and supply of renewable and low carbon energy and heat. Plans should, and then at criteria A, that there's some changed wording whereby adverse impacts now need to be addressed appropriately rather than satisfactorily, as was the case in the previous NPPF. And there's some additional wording around future repowering and life extension. Your view, please, as to the extent to which these changes are relevant to the determination of this application.
I don't think they have any relevance at all in the context of the current of this inquiry proposal. The The changes are very modest. Just a few words. They relate to the repowering and life extension of existing schemes. And of course, that doesn't apply here. Essentially, this part of the NPPF refers to the future planning of renewable sites.
Good, thank you. Moving on then to our fourth topic, best and most versatile agricultural land. You deal with this in your main proof at section 10, pages 26 to 28. And again, just a short point, you have attributed moderate negative weight to the loss of productivity or flexibility associated with the use of the land for sheep grazing, although you identify that the land won't be lost overall from agricultural use. When you drafted your proof, you obviously hadn't read Mr. Kernan's evidence, and clearly we haven't yet heard from Mr. Kernan in person, but I'd like to understand if there's any update on your view in the light of his evidence.
There is. Again, I qualify my response by reminding all present here that I'm not an agricultural advisor. I'm not practicing in the realms of agricultural land classification and farming practices. But what I read from Mr. Kernan's proof was that whilst in a local sense, a development area of this size, approximately 88 hectares, is clearly a substantial area of land in the eyes of those living nearby. In a broader sense, it is but a small part of this nation's agricultural land and a very small part of land given over to cereal production. I think Mr. Kernan's conclusion was that the contribution in terms of agricultural yield, the production of grain and so on of this site, actually is tiny in the larger national context. That's not to diminish the importance of retaining and utilising best and most valuable land, but I think it does cause me to think that to review my assessment of weight to be attributed to the proposal, which is tempered by the fact that there is a continuing agricultural use proposed. So on reflection and with the benefit now of some additional information, I think I would now be minded to apply rather more limited weight to the loss of agricultural productivity.
Okay, thank you very much. And then our fifth and final topic is your conclusions. So your main proof of evidence, paragraphs 13.15 onwards. You firstly deal with the heritage balance, and you explain that you have undertaken the balance required by paragraph 202 of the NPPF, and that you consider the public benefits would outweigh the heritage harm. Have you got anything to add to that?
No, I haven't. Thank you.
Good. And then you deal with very special circumstances at 13.16, and you explain your view that you consider this proposal to give rise to very special circumstances. In the light of the evidence you've heard this week, have you got anything to add or anything else you'd like to say in relation to that?
Very little, except that what we have heard this week, and indeed since I drafted my my proof approximately 6-8 weeks ago, it seems that barely a week goes by that we don't hear of some other consequence of climate change and the pressing need to produce energy from renewable sources. There are voluminous amounts of information which are provided in the core documents which demonstrate the clear and pressing need for renewable energy and the speeding of delivery of such initiatives to address what I think is widely accepted in this room is a pressing and urgent climate change crisis. Thank you.
Good. And then finally, you said when you read out your summary proof that you consider that the development complies with the development plan as a whole, notwithstanding two areas of conflict that you've identified with policy NE2 of the local plan and policy GB1 of the neighbourhood plan. Is there anything that you'd like to add to that particular conclusion?
No, I think I've been clear on that.
Thank you very much. Those are my questions, Mr. Robinson. Is there anything else you'd like to say, or are you content to leave it at that?
I'm happy and
Thank you very
happy
much.
to entertain further questions.
Thank you, Mr. Robinson. I'm sure you won't be disappointed that there will be some questions
I'm sure.
coming your way after the lunch adjournment, which we'll take now. And could we resume, please, at 2:15? Inquiries adjourned.
So just before we do
Yes.
that, would it be sensible if I gave you a copy of the conditions?
Conditions, please
Yes.
do, Mr. Hardy. Yes, that'd be very helpful. I do.
Sorry, sir. Can I just confirm? Am I in purdah at this
No.
point? No. Thank you.
Thank you. Thank you. We are adjourned. Good afternoon, everybody. Time for the inquiry to resume. And first of all, I just want to go back to the discussion that we were having earlier about the evidence with regard to the laying of the cable and how that could best be dealt with, given the evidence that the inquiry's heard. I think in the circumstances, given that there are two separate witnesses involved for the applicant, I think that probably the neatest way of dealing with it at this stage of the inquiry would be to give the applicant the opportunity to put a note in, as was suggested by Mr. Hardy, and then give the opportunity for JOG to respond in similar fashion. Clearly, if there remain any subsequent points that parties wish to raise, I would want those to be made in closing rather than have a further right of reply, Mr. Hardy.
Yes, absolutely.
In terms of timescale, given that we haven't got a lot of time left, bearing in mind site visits next week, I was going to suggest Monday for the initial note, if that's doable with the two witnesses.
Mr. Yeah.
It is for me, sir.
Yes, I haven't spoken to Mr. Kendall,
Yeah.
but we will make, well, we'll call him this afternoon to see what we can do. But yes, Monday, absolutely, if we can.
And then Tuesday for JOG to respond. And Ms. Staley, you're a main party, so I must give you the opportunity if you wish to.
That's fine. Yeah, I'm very happy to have an opportunity to respond in the same timescales as JOG.
Well, I want JOG to have the last word
Ah, okay.
on this one, because
Well, then in that case, as in you'd like JOG to see anything we have to say about
Yes.
it.
I know
Well,
that makes it
if I receive the note on Monday and JOG have to respond to it by Tuesday,
end of play on Tuesday.
then let's say by Monday lunchtime, the council will say whether or not it intends to make a response, and if it does, it will produce a response.
Well, you may not have seen it by Monday lunchtime.
Oh, sorry, by
Tuesday,
Tuesday lunchtime.
yes.
That's what I mean. Is that acceptable? Sorry.
Yeah. And there's the question of the photograph showing an
Yes.
example of a panel, how it might be.
I've circulated that. So I'm
Yes,
just inquiry documents. I want to just make plain that that is not a specification.
No, it's an example of how it could be done.
Commercial supplier of concrete ballast blocks for solar farms, but it's just the gives you an idea of the certificate dimensions of the slate.
I think in fairness, given the fact this only arose this morning in response to my question, but that there was nevertheless the opportunity for the applicant to comment on it. I'm going to give Mr. Harding a chance to comment on it later today if he wishes.
Sure. The other thing that crossed my mind.
Yes.
Another way of dealing with this would be to have a second part to the note, so that Dr. Tilford's doing the note, whether or not he puts a paragraph in about whether or not, having seen that arrangement, that alters the evidence that he's given in relation to the surface pathways. I think you've probably got enough evidence anyway.
Yeah, I'm not sure. That,
you don't need to go.
I
we
don't
need
think I
to go
need
there.
that. No.
Okay.
No, I think we'll just keep the notes on the one topic, please. You content with that, Mr. Harding? Yeah, good. I'll put that one side then for now. And then we're back to Mr. Robinson. Evidence in chief's finished, so it's questions, Mr. Harding.
Right, thank you, sir. And good afternoon, Mr. Robinson. I will try not to keep you too long from my point of view. Thank you. You gave us your qualifications and experience. Whereabouts are you based, and what is your knowledge, if you like, of the area in North Hertfordshire?
I live in Bedford. I have worked for a Hertfordshire local planning authority for 5 years, ending that association about 20 months ago.
Right.
So
Which one was that?
Welwyn
If we could
Hatfield
ask.
County.
Welwyn Hatfield. Okay.
And as part of my daily commute to Welwyn Garden City, I would pass this site twice a day on the A1.
Okay, that's fine. Thank you. So, yeah. So if we move on then into the heart of your submission, the first point is Greenbelt one, and I think you state inappropriate development in the Greenbelt, and I would just get you to confirm that to us and confirm everyone that you certainly agree that, as do other parties.
Yes, that's correct. I think that's common ground.
Yeah. And the important point there is you do accept it as development.
Yes, it is.
Yeah.
Yes.
And I think you make reference a little bit later to the comment, which I don't think was actually your observation. It was that only 3% of the site is developed. And what is your view on that definition of the amount of development?
You're quite correct. I think I say in my proof that I have not calculated the area of the supporting posts and so on. The reason that appeared in my proof at all was because I acknowledged that although the solar panels, principally the solar panels, although there are also, as you pointed out yesterday, ancillary buildings, they are fairly lightweight in form, comprising generally a metal frame with a solar panel. So I sought to, in saying that in my proof, I sought simply to illustrate the fact that it is not the same, not quite the same as a building, which would cover the same site. It doesn't have the same volume and mass, and in comparison is relatively light in terms of coverage and form.
But in the context of the definition of development of in, over and under the land, the panels themselves are development.
That's correct. And
Yeah.
of course, it's
Thank
a
you.
material change of use of the land.
Thank you. Yes. Yeah. Okay, moving on then. We then get to under 6.4, you're making reference to the North Herts local plan, and you acknowledge that that plan does not identify land for solar farms, renewable energy generation. Do you think it should do? Should there be a plan?
I think that it would be very sensible for the local authority to, at the very least, produce documentation that leads, that informs its decision making upon renewable schemes generally, and that would include solar farms. And indeed, that seems to be the thrust of the NPPF that's been discussed already this week. There seems to be a desire to see local authorities plan for renewable energy sites, including solar.
Thank you. Yes, I think the NPPF really does emphasize this word plan and to have a plan rather than it be, as one might say, a lottery as things stand at the moment as to whatever sites a developer and a landowner wants to come forward. Do you feel uncomfortable with the sort of scale of developments that you're seeing here, which are based on just opportunism and a lottery rather than a plan that has gone through a consultation period?
Clearly, were local planning authorities and its communities involved in the formulation of a spatial plan identifying areas for, let's say, solar farm development, or in the same way that it identifies land for new housing and new employment, would perhaps have an advantage in terms of gaining support locally and an understanding. However, it's not unusual for councils of all kinds to be faced with proposals which are not directly planned for. The nature of planning and development plan work is that it does take time over sometimes many years. I think the North Herts district development plan, so the local plan, took several years simply to get through the process of being submitted for consideration and ultimately being adopted. And in that time, there is no doubt that development demands may change, government advice may change, rules on permitted development may change. So there's a constant issue of development plans being up to date, which is why government advice is to review plans very regularly. But even in those circumstances, there is inevitably a lag. So I think the message has clearly been sent that local authorities should be planning for developments such as this through the consultation with local residents and councils and so on. But in the meantime, the world does not stand still. And if we use this as an example, there's clearly an imperative at national level for a speeding of the process of the delivery of renewable schemes. Were we to wait for this local authority and other local authorities to produce local plans, it could be quite some years down the line.
Okay. But this is a very large development to have outside a planned process. Would you agree?
It is a substantial site, although my investigation and consideration of the various example solar farm appeal decisions lead me to believe that actually it's not uncommon. Many of some of those schemes that we've discussed this week already would be in the region of 49 megawatts, and the site areas seem to be within a broadly similar range in terms of area. So I don't think it's exceptional in that sense.
Okay. Well, certainly wouldn't disagree with you over the length of time the local plan took. I think the council leader actually did say that, I think it's the leader who said she was still at school when the process started, and now she's council leader. So I don't think we deny that one. But in the end, it was an imperative to get that plan through so that there was control over the housing developments that were needed. And such, I'd have thought, should be the same for something taking up as major land as the solar farms. But anyway, moving on. Now, where do I go now? Where do we go now? Was it this point here? Yeah. Under 6.10, then you are, just to confirm, you are agreeing that both parcels 10C and 14F do make a significant contribution to Greenbelt purpose in our parcels of land.
At paragraph 610, I report
Yeah.
upon the council's
Oh, sorry. That's
review.
the council.
Yes,
review.
which
Sorry.
did conclude that overall both parcels made a significant
Yeah.
contribution to
And
Greenbelt places.
you agreed with that, I think.
I do generally
Yes.
agree with that.
Yeah. Yeah. Okay. Do you agree, though, that again, I think it's a council statement, in terms of the point there's only a very limited visual connectivity and therefore limited harm in terms of this area, because I think that contradicts somewhat the other comments about levels of harm. That's 612 from there. The bottom of 612. So where do we go to? The page 10, which is purpose A. Purpose A. Yeah, purpose A. Yeah. We're in purpose A then. Purpose B. Are you okay? Sorry, is that okay? I think, we're on purpose A here, I think, at the moment.
The paragraph 612 that you just referred to
Yeah.
is my commentary upon the applicant's assessment of purposes, which, and within that statement, I think within the, yes, this is from the LVIA. And I refer to the table 5.4 of
Yeah.
the planning statement. That is where the term very limited visual connectivity
Yeah.
arises. And I would agree to an extent. You know, my own personal observations from the site suggest that and indeed having seen the document, including the zones of theoretical visibility, for example, they confirm my view that actually the site is not terribly visible from many directions.
Yeah. Have you, in listening to the other evidence that has been going on the last few days, do you have some sympathy with the view that even if not entirely visible, it is important from the point of view of setting of the conservation area, setting of the priory, setting of the area?
Yes, absolutely. I think in my proof, I remark that you know, the lack of intervisibility is not the only measure of setting.
Yeah.
Clearly, it's a significant factor, because if one can't see between the heritage asset and you know, the application site in this case, you know, and they are not viewed together, then you know, the impact or the importance of the site on the setting would be reduced. But no, I repeat, it is not the only factor. There are other factors in setting which were touched upon in previous examinations this week. For example, the association that an area of land may have had with a heritage asset in the past. I think that Gravely Hall was an example that was mentioned, where it had become divorced over time from land which was once within its environs by the formation of the A1 motorway.
Yeah, I think actually that land had been within the farms from Great Warmley for many, well, hundreds of years probably actually. Yeah, actually the Gravely Hall was prehistoric, I think. Yeah. Anyway, so we just come to the purposes of Greenbelt, and purpose A, I am under severe instruction from my expert to point out that really this should be referencing the London Metropolitan Greenbelt, which should be, if you like, taken as a given as its importance, rather than trying to sort of turn that general Greenbelt purpose A towards our circumstance, and that should be really more to move on to primary ones for us, purpose B and C.
Yeah.
Yeah.
That I take it that's a question, Mr. Hard.
Well,
Like the way you put it.
it's yes. Do you agree with that?
It needs to
Will
be a
you
question.
agree with that definition? Yeah.
Were that definition to apply, and as I said this morning, I've no reason to doubt Mr. Griffith's superior knowledge on this subject over many years, then of course that would cause me to review my assessment in terms of purpose A and downgrade its impact, because clearly the development of this site, quite some distance now from London, does not contribute towards the, if I use the correct term, checking the unrestricted sprawl of large built-up areas. I don't. We're some distance from London, although I accept that it is, of course, within the Greenbelt.
Yeah. Okay. We'll move on. I think there is a deeper meaning to that London Greenbelt but under purpose B, we'll move on to, because I think it is purpose B and C that are critical for us. What are your feelings then about the distances between the towns, and and I think you make the point well that developments don't actually need to be absolutely touching each other to still for the Greenbelt to still play an important part in stopping the coalescence.
Yes, that's correct. I think, referring to my proof, I think you're probably looking at paragraph 623.
Am I? Oh, 2, 3. Yeah.
Correct me if I'm wrong.
Yeah.
Approximately halfway through that paragraph, I make the point that the quantum of intervening land maintaining a physical separation between nearby towns and villages would reduce as a result of the development proposed.
Yeah.
And that's what led me to conclude that, in my opinion, there would be an adverse effect upon the Greenbelt purpose B. And when I quantify that, I considered it a limited adverse effect, because there remains quite a substantial area of open undeveloped land. Clearly, if the site was still bigger, substantially bigger, it would have a greater impact upon that purpose, in my view.
Okay. And then moving to purpose 3, you accept there is no development and it would introduce development, so therefore you do see that as significant, just to confirm that.
Yes, I do, and I think that was the view of the council as well in its officer's report.
Yeah. if we then move on to the important question down at 6.30, you say there that you're conscious the proposal is not permanent, but a 40-year period is nevertheless a long time. From your planning experience, Rogiers, what are your thoughts about this principle of 40 years and permanence or temporary, please?
My planning experience leads me to apply the true meaning of words. It's important, in my view, temporary clearly is not forever, and therefore cannot be described as permanent. So I think it's important that words are written in the form they are written as for a purpose, even though that purpose sometimes doesn't suit one's own perspective. But the fact is, temporary is not permanent. However, to temper that, I think in my assessment of overall harm, I remark that I give little weight to that. 40 years is a long time in most of our lives. And for that reason, I acknowledge the point that I think Jog have been making, that it will be perceived as a long time, and it will be present potentially, if granted permission, for up to 40 years. After which, in accordance with the requirements of planning permission conditions, it would be removed, which is normal for this type of development proposal.
Yeah. We've reviewed a number of inspectors' decisions where they have actually not taken quite that same view of the word of definition of, or they've looked at the true definition of temporary as we did. If it was deemed permanent, and that was a view that was taken with that sort of length of period, would that alter some of your views on the impact on Greenbelt?
No, I think I've made clear in my proof that I've given little weight to the temporary nature of the development. I acknowledge 40 years is a long time.
Yeah.
And the effects of the development will be experienced for that duration.
Yeah. Okay. Thank you. Yeah. So we move on to move on. I think if we move on to landscape character now, which is starting at 7.7. Do you accept there's a spatial element and a visual element to the landscape character?
I accept that there's a difference between character and the appearance of the countryside. Character is a way that one might describe the physical attributes of a location, which in this case is helped by the prior drafting of documents relating to the national, regional and local landscape character areas. So we have that as a basis upon which to work. It identifies those features which might be particularly common in an area and which form, for want of the overuse of the word, to form the character of an area. Appearance is more, in my view, how the residents and visitors to an area would observe a location. And of course, these things are ultimately matters of judgment.
Yeah. Okay. Now, on judgment, there are some differences that you have highlighted between yourself and the LVIA and I think the TLP, and you consider, for example, the impacts to be, I think, generally greater than others have done. I think, is that fair? Without going into each a little bit separately.
I'm conscious that I'm not qualified in landscape character assessment. I'm not a landscape architect, so it's not my main area of work. But what I can say is that I have read and assessed both the applicant's landscape visual impact assessment and its conclusions, and I have compared them to the council's consultants, the Landscape Partnership, and their review of that document. And sitting in a neutral corner and having reviewed that, my personal and indeed professional view is that I'm more inclined to go with the level of harm identified by the council's consultant, which in the main is of a slightly higher level than that which was identified in the LVIA. But I'll also concede that those differences are quite modest, and they probably do boil down just to personal opinion. And I'd also say that as a result of the Landscape Partnerships review, the first form of the review, the applicant did, of course, make a number of changes, which I think are for the good of the scheme. And indeed, I think the Landscape Partnership acknowledged that they're all benefits.
Yeah. Okay, thank you. There's a conflict, and I guess we're as conflict as anyone else between a lot of those additional plantings of trees and hedgerows, etc., which are designed to, as far as you possibly can, shield views up close of an area of 218 acres. But of course, there's also the policies of openness, and there's the feel of openness of the whole site at the moment, as you'll see when you visit. How you felt in your considerations between the conflict, if you like, of the openness policies and the landscaping policies, which are almost creating we can view them as enhancement of landscaping, but they are reducing openness.
I understand your point. If you introduce an object relatively close to the viewer, you potentially obscure longer distance views. And that would apply to some of the boundary screening, certainly. On the northeastern boundary with the Hertfordshire Way, for example, currently one does have views across, when I visited the site, across fields full of arable crops. Today, those crops might have gone, I'm not sure. So I understand the point you're making. Landscape, in a way, is transitional, though. I strongly suspect, and I've read in various documents, that those fields and the extent of those fields and the views they afford may be relatively new in themselves as a result of field boundaries having been changed and removed to facilitate the sort of industrial scale of arable farming that is present on site. And I think we've seen some images of former field patterns. And I'm again, I don't claim to be an expert on that, but I suspect that is the case, which is in common with many parts of the country. the fields have grown bigger over the years.
Yeah, yeah. Okay, thank you. So I'm whipping on so as I don't take up too much time. I think I moved right up to 10.3 at this point now. And you're talking about national policy guidance and siting of large-scale solar farms, and I think you reference the installation at Leeming, Hambledon district. And is that, there's probably similarities, but is that a greenbelt example?
I would have to check on that, to be honest. I can't recall. That's CD 121.
I think it's just an important factor when we're talking about a lot of greenbelt. If we're using examples, it'd be good to know whether it is.
If you bear with me. Document 121 is. I'm sorry, I'm not sure I've got the right.
Okay. Or don't, maybe that's something you can look at, but I think we should, my understanding is that it probably isn't, and it shouldn't be looked at as a greenbelt comparator. But maybe it's something we can check, because I'm not absolutely certain. Are we going to move on, or are you looking for that still? No, I wouldn't look for it. We'll move on. Yeah.
One appears to relate to a site at Feltham Lane in this.
Oh, okay.
Unless
they've got.
If you bear with me, I can go to.
Yeah, no, don't worry. Don't worry. We can.
I'm sure Mr. Robinson can come back on that later.
Yeah, he can come back. I think they've clearly got muddled. Yeah, the reference here. So we're on agriculture, and we're actually we're pleased to see your statement in 10.5, where food security and reduced agricultural productivity is an important material consideration be weighed in the planning balance. And so do you accept that and agree then that the climate change challenge does have a food security as well as an energy and zero aspect to it?
I do accept that the protection and preservation of high-grade agricultural land is an important consideration. I'm not aware of such high level, in the same way that there is very high level governmental support for renewable energy, and with warnings about failing to do anything, the absence of action. I'm not sure that the same level of importance has been articulated with regard to best and most valuable agricultural land. And I think we heard yesterday from Mr. Griffiths that, if anything, the level of importance given to agricultural land appears to have been watered down. I tend to agree with his conclusion on that.
Okay, yeah. The politics swings and sways on that one, doesn't it? Yeah. So I think we won't go through the other matters, because flood risk etc. Highways, because we have, I think we have covered those elsewhere. And I think it's interesting that, and this may bring in an aspect which is slightly off field, but it's interesting under noise, for example, that this is always seems to be considered a neutral matter and there's no harm and no impact. But last night, as I understand it, and I'm not sure whether you're up to date on this, but the Bygrave solar farm was considered and deferred on a number of issues, including noise, and as well as biodiversity and other things. So slightly off centre, but it is North Herts district. It is activities that happened in this room, and it's interesting that we don't seem to have noise, anyone willing to get that up the agenda, but it was actually an issue last night. And so it's probably somewhat beyond your brief, but do you have any views on the noise implications during construction or post-construction?
What I can say is that during the normal course of the application, there was a consultation undertaken with the council's environmental health team, whose job it is to assess in the interests of public protection issues such as noise and contamination and health. Their response was essentially no objection, subject to conditions. I think they were satisfied on the basis of the evidence provided accompanying the application that there was unlikely to be a noise issue. And I think that was probably a factor of its distance from nearest dwellings. I don't doubt for one moment that during the course of construction there will be construction noise, but that source of activity and noise is some distance from people's homes, and it is of a relatively short duration. So, and I suspect that's what informed the environmental health officers in their response.
Yeah. Okay, thank you. Let me just, is there anything else we want to cover? Yeah, I think, yeah, when you get towards the end, we've got the various weightings, and I won't go through all the weightings for the other the other ends, but on Greenbelt, I think you have got Greenbelt openness as significant, then Greenbelt purpose is only modest, and I thought moderate, and I think we felt that actually contradicted some of the things you'd said earlier. And indeed the overall effect is substantial. You agree, but I think I don't know whether it's what you feel about that as a question, or we're just noting it that it seemed out of kilter with what you'd said previously. Do you want to review that?
No, I don't think I wish to review that. I think the reasoning for that is openness, I think, speaks for itself. The site will be less open than it is currently. Purposes, I touched upon my reasoning for that. And if we, and perhaps I would slightly revise that assessment, but I don't think it falls within the top category of harm because of its position relative to its surroundings and its size relative to the wider areas of open space around it. But it does carry it does have an adverse impact, and I apply moderate weight. Overall, then I think, as we've heard before, the start point here is that this is inappropriate development and is by definition harmful. And in addition to that, there are harms to the purposes. So I think a substantial level of harm is an appropriate assessment.
Okay. Thank you.
Thank you.
Is that, are we done? Yep. Yep, we're done. Thank you very much, sir. And thank you, Mr. Robinson.
Thank you.
Thanks, Mr. Harding. Mr. Robinson, the first thing I want to ask about is something that I don't think you actually cover in your proof, but I just wondered if you could possibly help as the only representative giving evidence from the local planning authority. I think right at the beginning of this inquiry, there was a reference to by Mr. Hardy in opening for the applicant that in this authority there'd been no permission for solar installation since 2015. Earlier on again in the inquiry, Jog referred to a site, I think, close to Little Wymondley. Can you assist as to what that is?
I believe I can. I believe it is the case that prior to the submission of this application that we're dealing with today, the previous applications, or the most recent application for a solar farm, which was on a smaller scale, dated from 2015. I believe that the solar farm that Jog are referring to as close to Little Wymondley, I'm looking for help here, was received after the submission of this plan and remains undetermined. There is no decision on it. So there is an application actively being considered, but not determined.
Right, so there's a current application in this part of the district for a solar proposal.
Yes.
Do you know the size of the proposal?
I believe it's a little smaller than the one we're considering now. We can.
I'd like to
probably-
know.
We can find that information out for you, I'm sure.
So I can because it is in Wymondley Parish as well. So we're
Well, I'll
fully
wait for the
versed in-
information to come from the local authority.
okay. Okay, that's fine.
Yeah, thanks. Turn to your proof now. Yeah, Mr. Robinson. Section 4. I think my note is 405. You're talking about planning practice guidance and refer to that in relation to renewable energy.
Yes.
Now there's a reference in that section of the PPG to the written ministerial statement of, I think it's 2015. What's your view of the relevance of that?
I'm sorry, you've lost me in terms of the
Have you got the
reference.
PP? Well, perhaps go to the PPG.
PPG or PPF, NPPF.
No, the PPG. It's in the core documents.
Yeah,
I'm using a hard copy, but I'll find you the reference.
thank you.
CD 64F.
Renewable and low carbon energy.
Yes.
Yes.
Yeah. And then if you go into that, it's the reference is perhaps not the easiest to follow in the PPG, but you find paragraph 13.
Does that have a page number?
Well, I don't know if mine would be the same. I'm using my own hard copy, which it says it's page 8 of 21.
No, different page number. Paragraph 13.
It's under the heading, what are the particular planning considerations that relate to large scale ground mounted solar photovoltaic farms?
Yes, I have that. Yeah.
And I just wanted to draw your attention to the second bullet point.
Beginning where a proposal involves greenfield land.
Yes,
Yes.
and there's a cross-reference there to the written ministerial statement.
By the Minister for Energy and Climate Change.
Well, that's a speech. There are two cross-references. There's cross-reference to the speech,
Sorry, yes.
and then further on,
25th of March 2015.
yes,
Was that the ministerial statement by Mr. Pickles at the time?
maybe it's called,
Lord Pickles, as he is now.
yeah, just referred to as planning update in terms of its title. I just wanted your view on its relevance in the case of this application.
Well, the first thing that strikes me, of course, is that was 25th of March 2015. Since then, there have been countless documents produced by government, including, of course, probably 2 or 3 revisions to the NPPF, most recently the one carried out only this month. I think clearly there are quite a number of material planning considerations that will be relevant to any large scale solar farm application. Included latterly would be the drive towards encouraging the provision of renewable sites, including on land which will encompass parts of the countryside. And I would refer to the ongoing acknowledgement in the planning practice framework that renewable, even within Greenbelt, is not prohibited. There is a high bar to achieve in terms of very special circumstances, and there's a wide range of consultation that is required and reports which need to be produced, such as landscape visual impact assessments and the like. But there is no prohibition upon the creation of solar farms within the Greenbelt and within the countryside more generally.
Paragraph 618
Of my proof,
of your proof, yes. The penultimate sentence of that paragraph, you identified, I think, a slight divergence in views from the council on a point
yes,
there, and you said you were going to endeavour to get clarification. Did you manage to do that?
I did, sir. Yes. Essentially, I've there is a slight difference in terms of significance afforded to the harm, and on discussion with the report's author, the conclusion is that it was an error. There is an inconsistency. There was an error, but I believe that it was clear from the committee report that the local authority, perhaps if we turn to the committee report, I'll get the precise wording. It's document 35A. In the section headed Greenbelt Conclusion, paragraph 4.578, the final sentence there, it is concluded that substantial weight should be attached to the totality of harm that will be caused to the Greenbelt as required by paragraph 148 of the framework. So whilst there was a degree of inconsistency in earlier parts of the text, I think it's clear from the Greenbelt conclusion the level of harm attached to the local planning authorities committee report.
Thank you. 625D, please, over the page.
Yes, sir.
The purpose to preserve the setting and special character of historic towns. As I've asked previously, I'd just like to know how you interpret historic towns in that part of the MPPF.
Of the MPPF.
Yeah. To what places would you apply that reference in D?
Taking words on their face of it, the nearest historic towns with a degree of history would be, in my view, Hitchin and Letchworth, to a much lesser degree, Stevenage. And I think in my assessment here, it is relatively distant from those two key towns of Letchworth and Hitchin. They are visible on the periphery of the horizon, but in my view, they do not. This site does not play a significant role in the setting and does not impact upon their special character of those two towns.
What about Great Wymondley?
Well, I remark in that paragraph 625, second sentence, it is close to Great Wymondley and to Gravely,
Yes.
neither of which are towns.
Right.
And my view is that the impact upon those are considered in the round
Yes.
in terms of the assessment.
Next, I want to move on to page 20. And paragraph 726. We're coming to a conclusion on landscape. You've taken here by Ms. Daly early today, asked for your view against that policy in the local plan.
Policy NE2.
NE2, yes. And you end up saying in 726 that you give moderate weight to the harm. What I'd like to know is if you give moderate weight to the harm that you've identified, how does that relate to a policy which refers to a scheme being unacceptable, which I think is in B of NE2.
NE2. Bear with me for a moment. I think it's acknowledged that there will be policies within a development plan which may I'll turn that around. Developments may be in conflict with certain policies and parts of policies within a development plan. And it would be unusual to find a scheme of development that was wholly compliant with every policy within the plan.
Yes.
Also, there's a general principle that one deals with residual harm in terms of the impacts of development. And that should take into account the application of mitigation, such as new landscaping, and the addition and application of suitable planning conditions, which are designed to reduce, designed ideally to avoid and reduce the adverse impacts of development to the point that it becomes acceptable in the whole. So I think
Yes.
what I'm saying there is that, yes, there is an element of conflict with policy NE2, but when considered in the whole, that conflict is overweighed by the benefits when one takes into account the level of mitigation that is possible.
But when you're considering the proposal and you describe the aspects of harm, is there anything in your proof that says that it would be unacceptable?
I don't believe there is on that front, no. Unless unacceptable in the context of policy NE2.
Yes. Yeah. Because you say you find conflict with policy NE2, but does policy NE2 require there to be no harm?
No, it does not. It's unacceptable harm. The implication is that a level of harm may be acceptable.
So it would be possible for a scheme to have a level of harm and still comply with NE2B. I mean, I appreciate there are other criteria
Yes,
to consider.
yes, that would be my view.
And then just a few small points just to check loose ends. that I've got. Just want to check something about the extent of the greenbelt coverage from the hard copy plan that was helpfully put in. It's core document 39D. So it's the sheet of the policies map that covers Hitchin, Letchworth and Baldock.
D.
Yeah. I hope I've
Yes, sir.
yes, 39D.
Yeah.
I've been comparing this with the key, which is on one of the other sheets, and it's not always easy to, in terms of the reproduction, to follow exactly what it is. But am I right in thinking that the green belt washes over Great Wymondley? I'm finding it difficult to tell what's happening there, because the conservation area appears to be shown by horizontal hatching.
Yeah, I'm afraid I have similar difficulty, and I must confess that I'm a little bit colourblind. So,
And it appears to be that if you
I
move
do
further,
struggle with maps.
well, if you go further south to Little Wymondley, that's quite clear that it's outside.
Yes, yes.
It's very different to how Great Wymondley is shown. Rather than guess, can somebody who's not colourblind check what the situation is? I'd like to know that.
Yes, that's fine, sir.
Yeah. Basically, what I want to know is, does the green belt just come up to the perimeter of the settlement, or does it go right across it? Thanks. And then you're being asked some questions this morning by Mr. Daly about the green belts and about the review. And I just want to make sure I've got the right references, because I think you referred to 2 reviews having taken place of the green belt.
Yeah.
And I've got the first one, which I think was 2016.
Yes.
And then I think you referred to a subsequent review in 2018? There was a further review.
That's correct. Yes.
And I've got the reference for the first CD 143. I haven't got it for the second.
I have that written down somewhere.
Can I assist, sir? On
Of course,
yeah,
yes, if you know.
it's CD 135. I don't know
Right.
why it's before the
Yes, because thank you very much.
earlier review, but that's where it is.
And final bit of tidying up on planning matters. The very first document that was put into the inquiry, which was the Freedom of Information response in connection with the fire services comments on the application. I presumed that that would have been a consultation response from the fire authority that came from, but I can't find reference to that in any of the documentation. I can't find it in the report to committee or in any of the supporting documents. Can you check whether there is such a document?
I think the answer to that is that your understanding is not correct on that.
Right, okay.
The fire service was consulted in the normal course of
Yes.
the planning application, and no representations were received, and that was reported in the planning committee report. My understanding is that the document you refer to has arisen as a result of a Freedom of Information request.
Oh, I know that, yes.
Subsequent to the planning committee. And in
I know that. Are you saying there is no consultation response, no original document?
That's correct. The fire service made no representations. I think they were
Right.
consulted twice during the course of the application, because of course it was revised during its consideration. They were consulted on each occasion, and I don't believe that they responded
Right.
to either of them.
Thank you, Mr. Robinson. That's all I want to ask you. Mr. Taylor, do you want to?
No further
Re-examine.
questions. No, thank you, sir. Just to assist on the fire risk point, the reference for the officer's report is 4.5.175 to 4.5.178.
Okay, thank you.
And that states, as Mr. Robinson's explained, that there was a consultation, but there was no response.
Yes, I didn't know there was a consultation, but I thought there may have been an original document. Thank you. Thanks, Mr. Robinson. That's your evidence completed.
Thank you.
Right, that's the completion of evidence for today. Just conditions. Now, the list only came out fairly recently. We can either go straight into it. I don't know whether, or I just wondered whether, as it's fairly new, whether you needed the opportunity to have a quick break now and have a final look at that, or would parties prefer to go straight on?
It might be good to have 5 minutes anyway, just to
Yes.
break. It's been going quite some time. What I was going to suggest was just to orient ourselves with the document. Given I produced it, I might just be able to give an overview. It won't take very long.
Yes.
That is the base conditions that were agreed are to a very large extent included, either unaltered, and there are some which are unaltered. So the archaeological condition, for instance, the transport condition, the flood risk condition are exactly as they were. There are others that have got the odd word changed or tightened up, but they're really minor amendments. There are then some additional conditions. So, for instance, number 7, the fire safety management plan, number 8, the lighting scheme, and there are a couple of others which are introduced as the construction traffic management plan, which is condition 5. So they are new.
Yes.
And then there are, to take, say, condition 2, approved plans that didn't have the list of plans on it. So I populated that with a list of agreed plans from the statement of common ground. So they are, what I will say is the ordering, the numbering is different because
Yes.
there seemed to me to be, there was some missing the statutory time period, all of that. So the numbering definitely is different, but the substance of what was in there has been transposed across in most cases. And so it's just a case of finding it. And can I say to you that this was, this is designed to try and help. People can have it in Word version, and absolutely not prescriptive about final form of wording. It's there as a guide, but the origin of the wording of these conditions came from 2 sources. One is the Secretary of State's decision letter at New Works, which is in the decisions in the core documents, and then secondly, the decision in relation to Cannon Barnes Farm, which is the Greenbelt decision that's also in the appeal bundle. So they are, I think we've got the numbers of those. It's CD 120. It is CD 122 and CD 126. So it's an amalgam of those.
Okay, thank you. Well, should we take 10 minutes then to have a break before we come back and review the conditions so far? Inquiry is adjourned. Resume, please, at 20 to 4. It's time for us to resume 20 to 4. Just before we go into conditions, I did say I'd come back to Mr. Harding if he wanted to make any comments on the photograph showing an example of a solar panel.
I think I do accept that this is purely related to the concrete blocks, because of course these panels are very low and you're getting no grass growth beneath them. But the only question I have for comment, these look as if they are sitting absolutely on the ground and not even buried slightly. I have seen some where there is they're buried sort of 200 mil into the ground, but these look as if, and is it intention that they will literally sit on the ground?
Yeah.
Yeah.
I think the reason this arose, Mr. Harding, was just my query about what the actual arrangement on the ground would be.
Yeah.
Where the
Yeah,
panel.
no, that's absolutely clear from here.
Okay, thank you.
It's perpendicular, yeah.
If it helps, the client's just instructed me that they will just sit on the ground.
Yeah.
So not going to be dug in.
Okay.
Right, conditions then. I think we can take this session more informally. And it would take, Stanley, has the council had an opportunity to have a look at the list from Mr. Harding?
We have had a look, but we did only, as you know, receive
Yes.
it this morning.
Yes.
So I don't think that I can give you a concluded position of the council
No,
today
not as-
regarding
no.
the acceptability of the
But
new
we're doing it a lot
drafting.
earlier than we would be doing anyway. It's
Yeah.
just a quick run through,
Yeah, and I'm perfectly happy to do that.
just to see, I mean, there may be some obvious points, others may require some more thought. Mr. Harding and Mr. Griffiths, have you had an opportunity to?
We're through most of it, but it's just been a quick read.
Of course, I think
Yeah,
everybody appreciates it.
we can
Well, should we go through it
comments.
in order?
Yeah,
Or-
yeah.
As we go through, I'll mention what the conditions are about for the benefit of those members of the public who probably haven't seen the list. And I'll start off with any comments that I may have, and then please chip in if points occur to you. The first one is just the statutory time period requiring the development to start within a period of 3 years, which has to go on as a matter of course.
Yeah.
The second suggested condition would identify the plans. And I think I've just got started off, just got 2 thoughts on this one, or maybe 3. I think two of the plans in the list would need updating because of things that have happened. Number 1, so I think we're now on revision B, the location plan. And in view of what I was told by Mr. Kendall yesterday, I think 16 also needs altering because it's got, I think 16 from memory shows 4 drawings, and Mr. Kendall said the first 2, which show an older version of the access, are superseded. So it either needs a caveat in there, or we need a revised drawing which omits those 2 swept paths.
Right, this was the list lifted from the statement of common ground.
Yes,
the
so
origin of
that's
it,
why
so,
it's out of date.
yeah.
Yeah. And then the other point, I've just got to find the cross-reference now because the order's changed. Yeah, it's condition 9 on this list, which is on page 4 under the heading of final details. That's asking for final details coming of the panels, the columns, CCTV columns. It says ancillary buildings, but am I right in thinking that would refer to all the buildings? Yeah, the buildings, the fencing. So most of those drawings that are immediate, they're there for approval, and then condition 9 seems to work against that, saying, in effect, saying that these are only indicative, although they've been approved, which is rather unusual.
Well, typical in renewable energy schemes, just because of above ground structures, technology moving on, what's available procurement wise, that's the reason. So it as you will see if you look at the conditions attached to the other schemes, it's fairly standard practice. But yes, you're right, there is. You're approving plans, and then you're allowing the final details.
Would it make more sense for the list in condition 2 to be reduced, and all the ones that are going to dealt with, all the matters to be dealt with under condition 9?
Could be.
It's just a thought to throw out, and we can come back to this next week.
I have no strong. I don't know what the council thinks. Got no strong idea. In the purpose is to have control and certainty for all. So whether it's dealt with under condition 2 or under 9 matters not. I'd have thought personally to have them listed in 2 is standard, and I wonder whether or not you then would be able to perhaps reduce the ambit of condition 9. It feels to me as though that would be the right way of doing that, just because then you've got a single plans condition. I mean, certainly have a look at it. I think just I suppose it's a long way of asking. So is that tension something that troubles you? It didn't trouble me, but if it does, then obviously we'll look at it.
No, it doesn't particularly trouble me. I just wanted to throw it out and see what comments came back, whether.
Fine.
But we'll return to that one next week. Mr. Harding.
To just mention that now, I mean, the point there that would trouble me is the final details, fencing, boundary treatments, gates. Now, we talked about this in our in our various submissions, that there is a big push by the insurance industry around getting insurance and the amount of theft going on, and we could find ourselves with a much more enhanced scheme of fencing that would be totally different from what's put forward now. And that could happen now or at some point in the future. And we want to guard against that happening in conditions. But even here, it's sort of almost allowing for final details to change something like the fencing or boundary treatments and gates than what we've been sort of crawling over up to now.
I think if it helps, Mr. Harding, it was actually designed to do the opposite. It's so that that any changes have to then be submitted to and approved in writing by the council. So what you have an approval, and if there were to be any change from that, then the council has to discharge that condition. Obviously, if it's not satisfied or it's something different, it would either refuse to discharge the condition, and indeed, because that's a consequence. Indeed, because that's a consequential determination, it would have to look at any environmental consequences that would flow from it. So in other words, the control, it's not just that change can be made, the council would have to approve any change.
Well, that's right. Changes couldn't just happen. They would be subject to the approval of the council. But I think Mr. Harding has a point in that what condition 9 does, it reduces certainty at this point in time in that JOG and local people don't know exactly what's coming, because although they've got details of buildings and fences, what condition 9 is saying, those could change to some extent. It's opening that possibility.
Well, that's absolutely, and if that concern, and I know Miss Hamilton raises or has raised that point, I think in relation to fencing, boundary treatments and gates, that maybe that from 9 that could be removed. I think it's really solar panels and frames, CCTV columns, potentially satellite that you might need to keep in 9. So I'd be
when it's not an outline application, it's quite unusual in terms of buildings.
So I was referring to 1, 2, and 3. So solar panels and frames, CCTV columns.
Yes, I know. Yeah,
So not 4 and 5.
that's
So
4 and 5. Yeah.
So 4 and 5 could be removed from 9 if that would give some reassurance. So in other words, you do know what you're getting in terms of fencing. That's on the approved plans, and then there would have to be a section. We're not absolutely not going down this, but if there was any application, then it would be through 96, and it would have to go through the process of determination and refusal.
Yeah, I think we're concerned that anything would actually have a consultation process attached to it. It's all right saying, "Oh, the council will approve it," but they can approve minor things quite readily themselves. But we would want it to have consultation.
Mm.
And I think the other point, we're just on the fencing, is that the fencing is there for security. And I think our argument is that if there's a problem on security and people getting through the fencing, the answer that we would seek is a different solution to simply making the fencing more security and more ugly, if you like, but to use technology, to use in all sorts of other security measures that could be employed, rather than to change the fencing. And that's quite you need some very specific I think conditioning there about the external envelope and how it may be changed.
Well, I'm happy in hearing that, sir. If it seems to me that if you took out 4 and 5 from condition 9, then that seems to me to give the level of protection that is being sought.
Yeah.
If it's helpful, Mr. So in our planning evidence next week, we were going to pick up this point about security, but it's just to give a precursor to that. That there's been talk about insurance companies and so on. The insurance companies in this case they're satisfied with post and wire stop-proof fencing, and actually the solution isn't seen as being putting more and higher and more metal fencing up, but actually CCTV and surveillance. So it's the positioning of cameras is seen as the way, a better way of dealing with that. So I hope that helps a little bit, Mr. Hart.
And that's just the solution I'm looking for.
Yes.
Technological solution,
exactly,
rather than
putting
a physical barrier solution.
Exactly.
It's just that there's a lot of solar farms have not gone down that route. They've just put up bigger fencing and more barbed wire, and we need comfort to know that that is not a solution that will be sought on this.
Can I say, I absolutely agree. I suspect that it's an issue which has only really come up in the last few months. I suspect those farms haven't had this issue debated. And the way, I'm absolutely listening to that, I think, is if you took out the variable or the subsequent details that you could find in condition 9 and left it as those plans which are approved, that's the level of comfort I think that we're looking to give. That would be my solution.
Okay. Right, thank you both. We'll bear that in mind for next week. I think my final thoughts on condition 2 probably relates to number 4, the general arrangement drawing. Now, I recall reading somewhere in the proposed that although the location of the buildings is shown here, that a degree of tolerance is sought as to their actual positioning. Now, is that consistent with what condition 2 says? I think it is difficult from that drawing to be absolutely precise about where the buildings would go.
So is the question, how certain is the operator about where it wants to put that?
But I don't think the operator is absolutely certain because of what's been already put in. I can't recall the exact degree of tolerance, but I'm certain that there's a reference to that.
Yes.
And if the operator wants that, and on a site of this size, it would appear it may be not unreasonable. Does condition 2 allow that?
So right. So that's a question we just need to look at. The solution then might be to take drawing 4 out. Is that out of condition 2? Is that what you're getting at?
No, because I think we need that. I think we need the general arrangements. It's just a question of interpretation, whether it achieves what, in effect, what the applicant wants if this scheme goes ahead.
Well, that's why condition 9 had that variability in it. So point 4 was ancillary buildings, equipment and enclosures.
Yes, I was reading it as the actual details of the buildings, but you're interpreting it
As
that could include position as well.
yes.
Okay. But that would run counter to what we've just been talking about, wouldn't
Well,
it?
it would certainly, well, it would leave 4 in, but we absolutely would take them five out. So fencing and boundary treatments and gates would come out.
Any other thoughts on condition 2? Condition 3 then talks about the duration of the permission and decommissioning. I think it's putting 2 previous conditions together. It's often usual with a temporary permission for the start date to be the date that permission is granted. That is not what's suggested here.
No, typical for renewable energy
Yes, I know.
schemes. And the reason for that is we're obviously trying to maximize generation and
Yes.
times of time, discharge conditions and so on. You're eating into the generational
Yes,
period.
understood.
That's difficulty.
Yeah.
Obviously you can take a view. We think it should be data first export, but if your recommendation of Secretary of State were to say that that's backdated to the date of permission, well, that's so be
What
it.
do you think, Mr. Robinson? In terms of the start for the 40-year period?
I understand the applicant's approach to this, but it is normal that the that the conditions would apply from the date of the consent. I have seen examples where developers have been required to provide local authorities with a written start date, which would allow, for example, the applicant to explore programming and availability of contractors and so on, and fix dates in that way, which might give them time for those preparatory works.
I think there's something like that in this condition.
Mhm. I'm sorry, I've not given much attention to the
It's okay.
conditions and viewed my evidence, but so that I think would be,
Yeah, the local planning authority has to be notified
yes.
when generation starts. So that would give you a certainty from that point of view. It's just a question of the approach to take.
Absolutely. So the notification, I think the notification, absolutely, you need a point, and there are a number of other conditions which refer back to the data first export. So that's certainty. The question is whether or not it's 40 years of generation,
Yes.
or it's 40 years minus the time it actually takes to procure, get the thing built. So you could actually end up with only 36 or 37 years of generation, because that's the debate.
Yeah.
And our view is that the excitation is to maximize generational benefit.
Yes.
That's
Noted. Thanks.
I'm not sure it goes to the benefit of jog, but I think I'd always rather worked on the assumption it was 40 years of generation to get the benefit. Yeah.
Okay, condition 4, construction management plan. This is a,
So
Sorry,
I think
Mr.
there is another important point on this.
Yes.
On the decommissioning. It's the certainty of so are we on? Yeah, is this decommissioning? Yeah.
yes,
Yeah,
three, yeah.
it's the certainty of decommissioning. And if we go back to the discussions with the local authority, and in fact, I think the observations made at the council meeting is approved. There was an understanding there would be a bond to assure that decommissioning could take place. Now, that's doesn't seem to be appearing here, but we have no,
I wouldn't have expected to see that. I mean, I don't know what's happened at the in discussions at the committee meeting, but I wouldn't have thought that would be a usual approach, and it certainly wouldn't be. I wouldn't have thought it'd be appropriate to include in a planning condition.
Right. Where should that appear then? I mean, it was discussed, and the thing is, we talked about, we don't know where this industry will go. We don't know whether the ownerships can change, the viability can change. What we don't want to have as a community is a white elephant just sitting there with nobody taking responsibility for decommissioning. And
there's a clear requirement in the condition as written for decommissioning to take place, and if that weren't to happen, for whatever reason, the council would have the ability through its enforcement powers to pursue that.
Well, but they may be pursuing it against against someone who's a complete straw man. And I think this was the point discussed by the district councillors at the time. So I don't know where that's gone, and I don't know whether the applicant has had that still in line. But there has to be. I mean, if there isn't absolute certainty financially, rather than just as a condition that you may not have anyone to apply against, have you got really a temporary? Is it temporary, or it could be permanent, or the costs fall on on someone else to remove it? It may be beyond
enforcement
realm.
action would be able to be taken against parties with an interest in the land.
That's correct, sir. The permission, if granted, will apply to the land rather than the applicant. And in the event that a company ceases to operate for whatever reason, then the owner of the land would continue to be liable, and the local authority could take enforcement action, if necessary, direct action, and place a charge against the land for future income. So in the event that the land was ever sold, whatever was owed to council would be returned. So there are provisions for preventing the scenario that JOG are anticipating or in fear of. We hope, of course, it will never happen.
So, and does the landowner then accept his liability? Because the landowner has never appeared in the picture at all in any of these discussions. Do they accept that liability then, if the applicant isn't?
It would be anybody with the relevant interest in the land. So yes, is the answer to that ultimately.
Yeah.
Perhaps finally, on this point, Mr. Harding, conditions aren't the place to deal with financial matters in any event.
No, well, I thought they probably weren't, but I think it's probably the only point where this point can be raised, and the fact that we mustn't lose sight of the fact it was a matter raised and discussed by the council.
I think, as far as I'm concerned, in terms of the decommissioning, the condition, from what I've read, that seems to cover that point.
Right.
Condition 4, construction management plan. this sets out measures to control how the development would actually be carried out during the 36-week construction period. Covers a range of matters, for example, waste management on site, the location and timing of sensitive works, the use of protective fences to protect the site and its surroundings. Comments from anybody?
The point I'd raise here is that 11
Yes.
is the point that we are having the note on. So that's in relation to spoil material
Yes.
on Stevenage Road. So yes, it needs to be in there. The extent and ambit of that probably to wait for the note and the exchange next week.
And I presume that's intended to fully address that point.
Yes, it is.
Is it intended that this clause deals with the archaeological investigations?
No.
Yeah,
That's elsewhere.
there's a set of 3 separate conditions, Mr. Harding, later on.
Okay, so the archaeological works sit outside the 36 weeks.
Well,
No, they predate them, I think.
Yeah, they predate the 30.
Yes.
Yeah, they predate them.
yes, but
yeah,
and they're
yeah,
subject to separate control.
yeah. Okay.
Number 5, and we're still with the construction period, and this is to do with construction traffic management. And it's a fairly standard sort of condition to control vehicle movements, how they get to the site, make sure that wheel washing facilities and so on are provided. Condition 6, landscape and ecological management plan is proposed. Condition 7, fire safety. I think this is presumably picking up the points from the fire service.
Yes, it is. And actually, I think what we need to add in there as well is battery. So the second sentence, the fire risk management plan shall include details of, and then response to fire risk management. I think we can insert battery management as well, because in terms of fire risk, the risk is actually more about batteries than it is about the panels and inverters themselves. So I think just it would be covered, but I think we can specify that.
Yes.
It's a battery safety management.
Yeah. I think it is unfortunate the fire service didn't respond and then have done it the way they have. But somewhere in there, it does need to make sure that it's not just the local planning authority, but the fire service does actually respond. I mean, if you go to that
Mr.
Liverpool,
Harding, it's a question of form. The matters should be submitted to the local planning authority because it's a planning matter.
yeah,
On something
okay.
like this, they would be expected to consult the appropriate authority before reaching their view.
yeah, but they have consulted, but they didn't get a response.
No, I
So
mean,
if you
consult on the management plan
on
that
the
came in.
management plan. Okay, yeah.
Condition 8 would control any external lighting. It's not saying that there has to be external lighting, but if it comes in, it can't be erected before a scheme's been approved. Condition 9 we've already talked about. That's the final details of certain elements of the proposal. Condition 10 is concerned with landscaping details. And then we're coming to archaeology next, Mr. Harding, which starts at numbers 11 to 13. Condition 11 is the scheme of investigation. That requires no development to take place until the revised written scheme's been approved by the local planning authority. And then a programme for the archaeological works, that's to be included in the scheme, and that's the requirement to adhere to that programme is in condition 12. And condition 13, no electricity exported to the grid until the site investigations being completed. Does that imply, Mr. Hardy, that some work could actually be going on before the scheme's completed? It can't be, because presumably quite a lot of work will go on needs to go on site before electricity can be generated?
The honest answer is I just took this as an agreed condition between council and the applicant without giving too much thought to how that worked. So your question would be, what can you do? So your question is, what can you do prior to export?
Yeah, number 11 says you can't do anything until the scheme's in and approved.
Yes.
That's just dealing with the scheme.
Yeah.
Number 12 says you carry out works on the site in accordance with the programme. So that depends what the programme says.
Yes.
And then number 13, you can't export electricity. So there's nothing actually at the moment saying you can't do work on site.
Although that would presumably be in the written.
You would expect that, but I just wonder whether it should be a bit.
Could be. So 12, the development shall take place in accordance with the programme of archaeological works. That's the mechanism. If we could make, but we could have a reference in there that's more specific to say something along the lines of would you be thinking no work? So, or
well, no, I think normally it would be a full pre-commencement condition that no work on site until the scheme of investigation had been completed.
Yes, as I say, it came from the council. We're happy with that.
I mean, that's what you'd see in many other forms of development.
I don't have an in principle objection to that by any means.
So just to tighten that up then.
Yes.
I appreciate this is it's a whole plan itself, but I do think it almost needs to sort of lap back into the construction management, because we're talking here about a level of earth movement and construction that's probably, if we're honest, going to be greater than the erection of all of the panels and everything. You're moving so much soil is going to be dug and sifted and sorted that it needs some, hours of operation, coming and going and everything else. It needs the principles of control of the construction management, because it's going to be quite a task in itself. Suggesting.
It's an interesting point raised by Mr. Hardy, because this is pre-development. Is it in effect covered by the construction management plan?
Well, it could be. You could have a reference to, or cross-reference,
yes,
in condition 4 to the archaeological works to be undertaken pursuant to the approved WSI. We could do that.
That should apply. Yes. Yeah.
So we could put a number 12 in there, cross-reference to.
Yeah. Well, it seems a simple way of covering it.
Yeah.
And just before we leave the archaeological section, what about the 3 no-dig areas requiring panels to be installed on the surface rather than by intrusive methods? I don't think there's anything in these 3 conditions which requires it, and I couldn't find it anywhere else.
It was just written into the WS. It would be written into the WSI. It doesn't go into that specificity. But if that was
well, given what we've heard about the archaeological importance, I would have thought it should be
just referenced.
Well, yes, I would think very strongly there should be a clear reference to no dig being included.
Then yes. So that
again, I think it goes back to certainty, and what people who've been following the inquiry would have a reasonable expectation would be taking place.
Yeah, well, that could go into 11 into that list, couldn't it? It could go into 11.7. So at the bottom of that could be that the scheme shall include an assessment of archaeological significance and research questions, and then it could be confirm I'll think of some other words, but confirm the no dig in the specified areas, or something along those lines.
Thank you. Then we come on to noise. And the first one, in effect, Mr. Harding, is sets out hours of work, which you've seen, which are fairly standard. Yes. And the second one in noise is condition 15, no noise generating plants, and it gives details of a specific report which has specified noise levels. I just wondered if that was, often noise conditions will specify a particular noise level rather than reference to a document such as this. Is that in this case the most appropriate way to deal with it?
Again, it was an agreed or a condition from the council, so I didn't meddle with it.
I presume then the council's quite happy if it's originated.
Yes, I think it's originated from the environmental health officer's comments.
Right.
Okay. The consultation response.
But this is a report presumably relating to the proposal.
Yeah.
Okay.
The wider issue on noise is the other one that was made about what if there is deflective noise, things like that, a problem out of the development. Now, what I know everyone's very sensitive about that around this area. After the situation on Todd's Green is that the wall was built, there was an acknowledged mix-up between the planning department and whatever other department, noise department, and this is a major problem, and nobody in the council, the developer, or anyone is taking any responsibility. So what we need to have somehow, and I don't know how it built in, but if there is a problem of noise deflection towards the villages, particularly Little Wymley, how is that going to be dealt with? Because or towards the Priory, I think it can't be just shrugged off for 40 years.
2 points in response, Mr. Harding. So next week in the planning evidence, we're going to deal with that. And again, to give a precursor, we've run that past the acoustician, Mr. Kettlewell, and the evidence will be that it isn't a difficulty in this case. So there'll be an evidential base for a submission that is not going to be a problem. But secondly, it isn't possible, I think, to put a preemptive position in a condition like this. Ultimately, it would be a nuisance if there was a difficulty caused by this. We absolutely don't think there is, but if there was, then there would be the powers of nuisance, and the council would be ultimately taking action on that basis.
There'd be other avenues down which that could be dealt with through. Yeah. Flood risk and drainage next, and I think on the previous list of conditions had two versions of this. At condition 7, I think there was
Yes.
there was one suggested by the local planning authority and one by the applicant, and I have to say, Mr. Ellie, I wasn't terribly keen on a reference to a consultation response going in a condition.
So if I may explain, the council's condition was the condition that the LLFA officer recommended. The council doesn't have any in-house flood expertise, and so the council was content to put forward the condition suggested by the LLFA. The council has since put the condition suggested by the applicant to the LLFA, and they have agreed it with a few amendments. So now we have an agreed position.
And 16 is the result of that.
16 is the result of that, and 17, which just extracts one of the paragraphs that was previously in 16 to deal with interim and temporary drainage measures during the demolition and construction phase as a separate condition. It doesn't change the substance. It's just a slightly different way of doing it. So there's no disagreement between the council and the applicant now.
And the lead local.
And the lead local flood authority, yes.
So it's a tripartite agreement.
It is a tripartite agreement.
And does that apply to 17 and 18 as well? So they're all, that whole suite of conditions is agreed?
Yes.
Good.
We're all friends now.
Condition 19, I wasn't quite sure what to make of this because But presumably I'll hear more about this next week in terms of the local wildlife site. But on the face of it,
It was generated by the council as well.
Yes.
It's a council condition, so.
Yeah, so I think this arises from a consultation response from Hertfordshire Ecology.
yes, okay. Condition 14 is there to protect trees, and then condition 20, condition 20. And 21, I think, is the one that was foreshadowed by Mr. Hardy in respect of evidence that we're going to be hearing next week concerning skylarks.
Correct.
So, Mr. Harding, that's a condition that Mrs. Hamilton needs to be made.
It
Oh,
is. So
no.
yeah, we won't comment on that one now, but
No.
we will make her aware of that.
Yes,
Indeed. Yes. Yeah.
good.
I think 22 is council generated too. That was the grazing management plan.
Yeah, did I have a queen? Yeah, I think just one query about this. This is a different start date. It's allowing a year, first of all, before you've even got to submit the plan. Why?
I didn't meddle with it. It was just
Where's it come from?
it's from the council. I don't know. I'm pretty sure it's from the council. I didn't meddle with the wording of
If
the
it's
one
from the
that
council, I'm surprised that the council's promoting a deferred start.
I can't assist you at the moment, sir, with the reasons why it's drafted as it is, but I'll take instructions on that over the weekend.
Well, is there any reason why it shouldn't be earlier? Well,
No, well, I can't see any reason why it shouldn't be earlier.
yes, that's true. So what Mr. Collins just said is that may be because it takes time for the grass to establish. So I mean, that doesn't stop.
no, that's not. It's the conditions requiring a plan.
Exactly. I was going to say that doesn't stop a plan
No.
from being submitted and approved. So we've got no problem with that coming forward. Make that the
No later than the date of first April.
I say no electricity shall be exported to National Grid until.
Yes.
Yeah.
Yeah.
This is another case where we're relying on the local authority, of course, to approve the plan, and there's no certainty that it's going to be material. I mean, the plan might come forward and we say, we'll put 6 sheep in one corner, and the local authorities say, yeah, that's fine, that'll do the job. And I have seen more than a number of those around that have sort of just about got the tick box in the corner.
Well,
That is not when the application comes forward and argues that agriculture can continue. There is actually, I think something in one of the papers telling you how many sheep you can have. I mean, how do we make sure it's material if that's the route you go?
Well, I hope you'd think more highly of North Hertfordshire District Council than that they'd approve a proposal for 6 sheep to be grazed.
I'll be honest, I don't. I'll be absolutely honest. No, I don't. No, and they've done nothing to suggest that they would.
Well, would I be right in thinking, Mr. Daly, that the local planning authority would give notification of details and undertake a level of consultation?
In relation to the discharge of conditions,
Yes.
I don't know the answer to that. I need to take instructions.
Might be
on that.
helpful to know that, and offer, if it does, that might offer some reassurance to local residents. Perhaps you could come back on that next week. And then we're onto a condition which is concerned with the additional rights of way that we heard about the other day, requiring a scheme for those to be made available, and then for their implementation. And then the final section of conditions concerns making sure that the accesses and the parking bay, because of the large vehicles during the construction period, are made available and then adjusted and reinstated as appropriate. And those are sort of conditions I would expect to see concerning highway safety.
And again, I haven't meddled with the wording of those. I have to say they seemed rather, I'm sure they could be telescoped, but I've got
Yes.
no problem. They can just stay as they are. They were as they were conveyed to me, I think, from the highways department.
Well, thank you for those initial thoughts, Mr.
Sorry, one more from me. I know trains to catch. There is a country to go to. My phone has been constantly hot on the
Yes.
subject of the access down Priory Lane, particularly when it was really established that it logically can't be left open. Where do we pick up the regime for access or rolling closures or working with the businesses down there to enable access and timings?
I think Mr. Kendall touched on that when he gave his evidence.
He did. I mean, we talked
and
about
referred to the procedure for dealing with that.
Yeah.
That's condition 5.
Is it?
So that's the construction traffic management plan.
So
No, I don't think Mr. Harding's talking about that.
well,
Right.
construction traffic.
Because that's the traffic management requirements. And
Well, if you're talking, I mean, I took that as being the construction traffic.
Yeah.
I'm talking about the general traffic and particularly high vehicle accessibility.
I think what Mr. Harding's talking
Yeah,
about, Mr.
down
Harding,
Priory
is
Lane.
when the cable is buried in the road and there are the temporary road closures along Priory Lane, he's wondering if that
Yeah.
would be covered by a condition. And I think what Mr. Kendall said was that there would be a requirement for the applicant to apply for license arrangements to cover that. And that, in effect, it will be dealt with by a separate regime.
that's true. But in terms of the what planning does, my understanding of that would be that would be picked up by condition 5, because that is part of the construction or associated. And what you could do in there is include a specific reference to so far as you can do, in planning, the
Condition 5 is to do with construction traffic. What Mr. Harding's asking about is not construction traffic, it's existing traffic, and how it's affected.
yes, but 5.3 traffic management requirement. Look,
I think,
if there needs to be a particular condition, I think the argument then would go, well, it's probably subject to separate licensing. And
yes, that's
that-
my thoughts.
is that
entirely.
outside the Planning Act? Yeah.
I think so. I think it's dealt with, Mr. Harding, but not here. That's my view.
Okay, I think Mr. Kendall's sort of response as well, there'll be a contractor and the contractor will have to put his plans together of how he'll do the work. But
Yes,
I think
what
it-
Mr. Kendall's saying is a contractor can't just come along and start digging up. A
no,
road.
that's right. But it makes it very third party operation, and we need to make sure there's some control of that and awareness of the need to consult that comes back to the applicant and the council, as well as a down the line contractor.
That's outside the Act. I think that.
Yes, I
there
do.
are- Yeah.
I mean, it's not unusual, Mr. Harding, when a major project has to go ahead, that there are various sets of requirements and conditions and permissions that would have to be acquired.
Yeah.
And they can't all and don't all ride on the back of a planning permission.
No. Okay.
So any necessary consents, such as undertaking intrusive works into the carriageway, that would have to be dealt with under a separate regime. That's my understanding.
Okay.
Now, was it your intention, Mr. Hardy, to amend this for next week?
Yes.
In the light of the initial comments.
Over the weekend, I will make, they're not, not too many amendments there. So I will make those changes and then circulate that for Tuesday of next week.
If you get the opportunity to finish it in sufficient time, could you send a copy to the inspectorate's case officer?
Of course I can. I'll do that, and I'll send it in Word format so that
That would be very helpful.
that's fine. Thank you.
Okay. Right, we will revisit conditions, of course, before the end of the inquiry. We know at the end of the business that we expect to deal with today. Before we adjourn, is there anything procedurally any of the main parties wish to raise? Mr. Hardy?
I don't think so. We've spoken to Mr. Kendall and Ms. Dr. Tilford. They're on with the note, so that will be
Good.
done in time. Apart from that, no.
Stephen?
There's nothing from me. Thank you.
Good, thank you.
And nothing from me, sir. Thank you.
Thank you all very much then.
Oh,
In terms of, we know we can leave the boxes here. Should I put my box as usual in the room I've been using, do you think, or?
I think so. I think that's
Okay.
fine. I think either here or in
Yeah.
your room. I don't think anyone's using these rooms over the weekend, so I think it's fine.
Thank you. Perhaps just one final point from me before we adjourn. That's just to do with the site visit arrangements, which will come up fairly quickly once we get to Tuesday next week. I did ask earlier if some thought could be given to extending that to include the other viewpoints. I think it was apart from viewpoint 12, which I wasn't unduly concerned about going to visit, but I would like to go to the others and the position where Mr. Griffiths' photograph was taken from. So that could be done a site of that, if it's possible on Wednesday, would be useful.
Yes.
Um,
I think there's a question of transport, and
yes,
we can arrange it.
I'd always, as a general point, like to start with the site itself rather than start further afield. So I'm happy with the starting point, which I think was in the centre of Great Wymondley. And I can make my own way there. Be useful perhaps to have, when the revised itinerary comes out, to have some an indication of timing on it as well. And perhaps I think we're going to take more or less a full day. So we need to make sure it's somewhere around about lunchtime that would be a suitable place to stop.
We'll come up with some timings and obviously share that with other people. And we have,
Thank you.
There is a car that's available that fit everybody in.
Good, excellent. Right, thank you very much. The inquiry is now adjourned and will resume here at 10 o'clock on Tuesday.